Lordship. Lordship, we have filed the affidavit yesterday, Lordship. It may take time to come the matter in the court, Lordship. So matter may be fixed on Tuesday, Lordship, which is 6 May. We have taken the due consent of the petitioner.
I appear for the respondent, to petitioner.
You have been served with a copy.
My lord, yes.
We can fix it on Tuesday. Some date will be fixed. Tuesday we are.
Maybe fixed on 13, Lord.
You know that the matter was fixed. Why did you file it yesterday?
No, Lordship, we took, we got late receiving the instructions, Lordship.
It will come up on 20.
20
Obliged.
obliged.
Lordship, in item 5, I have filed one additional affidavit, Lordship. Kindly the matter record may call for.
Please, your lordship. My lord, I beg to mention item number 14, my lord. Lord, conducting counsel is out of session, my lord.
14. Paper. Then it is made by counsel. On behalf of counsel for the
Made petition. My lord, the petitioners before your lordship, they are all NM nerds, but they were not appointed on substantive basis. And they are working over a period of time. So our prayer is, my lord, equal pay for equal work, our basic grievance.
equal pay with
The regular nurses, ANM nurses.
you are what?
We are also working as ANM nurse, but the source of recruitment is different. Same duties we are performing, my lord. Because Supreme Court has said, my lord, the source of recruitment cannot be a basis for classification. So let me, my lord, place the foundation of my case. I'll refer to few paragraphs in the writ petition, my lord.
Why is it for it's for admission hearing?
I'm hearing, my lord.
But I think it is for admission.
It's admission column.
Reply not file.
File, they have affidavit file.
Yes, we affidavit we have filed.
And my lord, affidavit, they have not denied that equal work file. That we are performing equal work, which is the most relevant fact, that they have not denied in their affidavit. So therefore, we have not filed any reply.
Yeah.
Now, please come to page 124, my lord, paragraph 2.
Yeah.
That the petitioners are presently serving as auxiliary nurse and midwife on contractual basis in different districts of the state of Assam. Petitioners have completed required training course to be qualified to practice as auxiliary nurse midwife. All the petitioners have been appointed as NM on contractual basis between 2006 to 15 at health sub-centers in different districts of Assam. Petitioners were appointed in the said post pursuant to a valid selection process. Petitioners have filed the instant writ petition before this honorable court, being aggrieved by the impugn action of the respondents in denying the petitioners to draw their regular pay at par with other similarly placed employees appointed on regular basis. As such, petitioners have a common cause of action, and therefore the petitioners have filed the instant writ petition jointly. Then my lord will kindly come to paragraph 4, my lord. That the petitioners beg to state that the petitioners have to discharge their duties on regular basis at respective health and wellness center. The duties of the petitioners include both field duties as well as to attend OPDs of health sub-center. Nature of duties of the petitioners as ANM nurse include maternal and child health along with family planning services, health and nutrition education, efforts for maintaining environmental sanitation, immunization for control of communicable diseases, treatment of minor injuries, and first aid in emergencies and disaster. Further, as a part of the field duty, the petitioners have to visit the house of every individual that falls under their respective primary health center to take care of health of newborn babies, children, as well as mothers. Furthermore, the petitioners are required to assist doctors in providing patient care as a part of their usual task. Additionally, the petitioners have been entrusted with the duties to assist incapacitated patients in dressing, washing, and bathing. Moreover, they have to take care to feed the patients at the appropriate time for breakfast, lunch, supper, and dinner. It is pertinent to mention herein that petitioners have also taken part in routine immunization process, which also includes visiting homes of the individual as well as respective schools. The petitioners have to ensure that every child studying in the school are getting proper and adequate health supplement in the form of iron tablets and vitamins, etc. Apart from that, the petitioners are also administered in preventing seasonal illness by providing necessary medicines. The petitioners humbly beg to state that petitioners in the OPD have to conduct routine immunization drive and also check up on the health parameters, as such giving necessary medical assistance to patients. Moreover, during their duty in OPD, petitioners have to attend emergency cases, actually attend, not attend, accident cases which occurs from time to time in area under their jurisdiction. Then Milord will kindly come to paragraph 8, Milord, at page 127. That the petitioners beg to state that the petitioners herein have rendered almost 20 years of service without any break under the Health and Family Welfare Department, Government of Assam. Moreover, petitioners have manifested their service whenever it is required by the department, regardless of any time, to serve the interest of the patients. It is pertinent to mention herein that petitioners had participated in the selection process, which was conducted in the year 2015 for filling up the post of A&M nurses. However, the petitioners could not come out successful in the said selection process. Though petitioners were not successful in the said selection process, departmental authorities had allowed the petitioners to continue to serve as A&M nurses on contractual basis till date. Evidently, services of A&M nurses are required by the departmental authority. Besides, most of the petitioners have now become overaged to apply for a fresh recruitment process for the post they are currently holding. Further, a representation was also submitted, etc., etc. Then Milord will kindly come to paragraph 9, Milord. Now, at para 9, at page 129, Milord, I'll read from the 5th line. Be that as it may, petitioners perform the same function as regular employees, that is ANMs. It is a tried law that difference in source of recruitment is no ground for differentiation between contractual ANM and regularly recruited ANMs, where the qualification, functions, duties are similar. Most pertinently, the petitioners and regular ANMs are being employed by the same employer, that is the state of Assam, which is one of the requirements for invoking the doctrine of equal pay for equal work. Para 10, that the petitioners beg to state and submit that some of the requirements as envisaged by the Apex Court for invoking the doctrine of equal pay for equal work may be summarized as under. Employees ought to be employed by the state as casual, daily rated worker, contractual basis, etc. Employees ought to have worked as such for a fairly reasonable time, satisfying the ingredients of continuity in service. Functions being discharged by such employee should be similar as that being done by regular employee of the same department. Work performance of the employees should be satisfactory. It is therefore respectfully stated and submitted that petitioners fulfill amongst others all the above requirements, and hence this court may be pleased to invoke the doctrine of equal pay for equal work to the facts of the present case as prayed for. Then para 11, Milord, finally, that the petitioners humbly beg to submit that petitioners are working at a lesser wage only to provide food and shelter to their families at the cost of their self-respect, integrity, and worth. Needless to say, the petitioners' dependent would suffer immensely if they refuse to accept lesser wage. Present case is a clear example of violation of fundamental rights guaranteed to the petitioners under Article 14, 16, and 39D of the Constitution of India. It is an admitted fact that petitioners have been paying less wages as compared to similarly situated state government employees. in the humble submission of the petitioner, said impugn action of the state respondent is an act of exploitative enslavement emerging out of domineering position of the state. So, my lord, these are the, foundation on which we lay our case. Now, let us come to the affidavit filed by the state, my lord. Now, para 5, first come to para 5, my lord. There they are dealing with para 4, where we have explained what duty we perform. That with regard to the statement made in paragraph 3 and 4 of the at page 156, my lord, that with regard to the statements made in paragraph 3 and 4 of the writ petition, deponent begs to submit that petitioners were to attend their allotted duty as per terms of the contract, so executed as mentioned in the copy of the appointment order for contractual engagement. So there is no denial. Then, my lord, now para 8, sorry, my lord. I won't take over. Now, in para 5 of our writ petition, my lord, we have also explained regarding the nature of the duty. Now, in para 6, they say at page 157 that with regard to the statement made in paragraph 5 of the writ petition, the deponent begs to submit that the petitioners perform their duty as ANM to the post to which they have been appointed. So there is no denial here also. Then, my lord, will kindly come to paragraph 9 of their affidavit, which deals with our contention in para 8, where we have said that we are serving for the last 20 years and that there was a recruitment process where we participated. We could not come out successful. Then now we have become overaged for any government recruitment. That with regard to the statement made in para 8 of the writ petition, deponent begs to state the petitioner submitted a representation on 31/3/23 to the Commissioner and Secretary to the Government of Assam Health and Family Welfare Department with request to grant them equal pay for equal work. Thus, in this connection, the deponent begs to submit the deponent is not related to this matter. Further, the deponent begs to submit that since the appointing authority of state is not Director of Health Service, thus Director is not in the authority to raise their salary as claimed by the writ petitioner. So, passing on the buck. Then, my lord, please come to our para against para 9, where we said, my lord, we perform similar duties as regular ANMs. Now, this is very important. That with regard to the statement made in para 9 and 10 of the writ petition, deponent begs to state, government is the authority for grant of equal pay for equal work, and director is not the appointing authority and also not the authority to grant equal. So they are not disputing that we are discharging similar function. So, therefore, we never felt it necessary to file any reply to this affidavit. And they have said, now, my lord, I'll place the case laws on the point. In my humble submission, my lord, subject to what your lordships may say, it's an open and shut case, my lord. And lordships will also come to para 14, my lord, at page 160. Page 160, para 14, my lord. That with regard to the statements made in para 14 to 16 of the writ petition, the deponent begs to refer and rely on the document annexed in Annexure C under page 141 in respect of Doivoki Pegu as ANM bearing dated so and so. The deponent further begs to submit that the government and National Rural Health Mission are competent authority to dispose of the matter regarding equal pay for equal work in the line with salary of regular ANM appointed against sanctioned post. So virtually, my lord, the director is supporting our case. My lord, as far as the case laws are concerned, first I would like to refer to, my lord, 1986 1 SCC 637. Aisane? What set lohibo lagsil na?
1986.
1 SCC 637, paragraph 2.
Name of the party.
Name of the party, my lord, Dhirendra Shamoli versus State of UP. What set lohibo lagsil na?
No, don't worry. We'll get it here.
Yes, okay.
We have the digital access.
Okay.
Yes.
Yes. Please come to para 2, my lord. A writ petition have been initiated on the basis of two letters, one addressed by Dhirendra Chamoli and other by Mohan Singh, both of whom are employees of Nehru Jubak Kendra, Dehradun. The complaint made in the writ petition is that there are a number of persons who are engaged by Nehru Jubak Kendra as casual workers on daily wage basis, and though they are doing the same work as is performed by class 4 employees appointed on regular basis, they are not being given the same salary and allowance as are being paid to class 4 employees. Then Lordship may kindly skip some of the portions. If a Lordship kindly comes to the middle of the page, the argument is noted. But while raising this argument, has a Lordship noted that, my lord? After about 10-12 sentence, or please come to this, my lord. The argument envisaged in the counter affidavit, has a Lordship got it? After about 7-8 lines, the arguments envisaged in the counter affidavit, has a Lordship? Yes. The arguments envisaged in the counter affidavit is that since there are no sanctioned posts to which regular appointments can be made, the casual employees by different Nehru Jubak Kendras cannot claim to receive the same salary and perquisites as class 4 employees appointed regularly to the sanctioned post. But while raising this argument, it is considered in the counter affidavit that persons engaged by Nehru Jubak Kendra perform the same duty as is performed by class 4 employees appointed on regular basis against the sanctioned post. If that be so, it is difficult to understand how central government can deny to these employees the same salary and condition of service as class 4 regular employees appointed against sanctioned post. It is peculiar on the part of the central government to urge that these persons took up employment with the Nehru Jubak Kendra, knowing fully well that they will be paid only daily wages and therefore they cannot claim more. This argument lies ill in the mouth of the central government, for it is an all too familiar argument with the expliciting class and a welfare state committed to a socialistic pattern of society cannot be permitted to advance such an argument. It must be remembered that in this country where there is no such unemployment, the choice for majority of the people is to starve or to take employment on whatever exploitative terms are the terms are offered by the employer. The fact that these employees accepted employment with full knowledge that they will be paid only wages and they will not get the same salary and condition of service as other class 4 employees cannot provide an escape to the central government to avoid the mandate of equality enshrined in Article 14 of the Constitution. This article clearly declares that there shall be equality before law and equal protection of law, and implicit in it is the further principle that there must be equal work, equal pay for the equal work value. These employees who are in the service of different Nehru Yuvak Kendra in the country, who are admittedly performing same duties as class 4 employee, must therefore get the same salary and conditions of service as class 4 employee. It makes no difference whether they are appointed in the sanctioned post or not. So long as they are performing the same duties, they must receive the same salary and condition of service. Well, it's a clear authority on the proposition. You are. ঠিক আছে? এটুকু বলে দেন। দুটো বলে দিন। Yes. Then Milord will kindly take this Randhir Singh's case, Milord, 1982, 1 SCC 618. My lord, I place the judgment first, this Dhirendra Chamoli's case, because often, my lord, an argument is advanced by the state that with your eyes open, you have accepted the employment. Now, therefore, you cannot turn around and say that you are being discriminated. The whole idea was to, my lord, deal with that contention of the state, which often comes forward. Because these people have no choice. Otherwise, they will have to starve. 1982, 1 SCC 618, para 8 and 9.
Eighty-two.
1982, 1 SCC 618, Randhir Singh versus Union of India. It's a famous case, Milord, on this point.
Para.
Para 8 and 9.
Yeah.
It is true that principle of equal pay for equal work is not expressly declared by our constitution to be a fundamental right. But it is certainly is a constitutional goal. Article 39D of the Constitution proclaims equal pay for equal work for both men and women as a directive principle of the state policy. Equal pay for equal work for both men and women means equal pay for equal work for everyone and as between the sexes. The directive principles, as has been pointed out in some of the judgments of this court, have to be read into the fundamental rights as a matter of interpretation. Article 14 of the Constitution enjoins the state not to deny any person equality before law or equal protection of laws, and Article 16 declares that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. These equality clauses of the Constitution must mean something to everyone. To the vast majority of the people, the equality clause of the Constitution would mean nothing if they are concerned with the work they do and the pay they get. To them, equality clauses will have some substance if equal work means equal pay. Whether the special procedure prescribed in a statute for trying alleged robber barons and smuggler king or for dealing with tax evaders is discriminatory, whether a particular government policy in the matter of grant of license or permit confers unfettered discretion on the executive, whether takeover of the empire of the industrial tycoon is arbitrary and unconstitutional, and other questions of the like nature, leave the millions of people of this country untouched. Questions concerning wages and the like, mundane they may be, are yet matters of vital concern to them, and it is there, if at all, that the equality clauses of the Constitution have any significance to them. The preamble to the Constitution declares socialistic democratic republic. Again, the word socialist must mean something. Even if it does not mean to each according to this need, it must be at least mean equal pay for equal work. The principle of equal pay for equal work is expressly recognized by all socialist system of law. That is section 59 of the Hungarian Labor Code, para 2, section 11 of Czechoslovak Code, section 67 of the Bulgaria Code, section 40 of the Code of German Democratic Republic, para 2 of section 33 of the Romanian Code. In this principle has been incorporated in several Western labor codes too. Under provisions of Article 31, Section 31 of Book of the French Code, so and so, and according to Argentine law, this principle must be applied to female workers in all collective bargaining agreements. In accordance with Section 3 of the so and so of the German Federal Republic, Clause 7, Section 123 of the Mexican Constitution, the principle is given universal significance. Preamble to the Constitution of the International Labour Organization recognizes the principle of equal remuneration for work of equal value as constituting one of the means of achieving the improvement of condition involving such injustice, hardship and privation to a large number of people as to produce unrest so great that peace and harmony of the world are imperiled. Construing Article 14 and 16 in the light of the preamble and Article 39D were of the view that principle equal pay for equal work is deducible from those articles and may be properly applied to cases of unequal scales of pay based on no classification and irrational classification, though those drawing different scales of pay do identical work under the same employer. There cannot be slightest doubt that drivers in the facts of this case, drivers in Delhi police force perform the same function as duties of other drivers in the service of the Delhi administration and central government. If anything, by reason of their investiture with the powers, functions, and privilege of a police officer, their duties and responsibilities are more arduous. In answer to the allegation in the petition that driver constables of the Delhi police perform no less arduous duties than drivers in other departments, it was admitted by the respondents in their counter that duties of driver constables of Delhi police were onerous. What then is the reason for giving them a lower scale of pay than others? There is none. The only answer to the respondent is that driver of the Delhi police force and other drivers belonging to different departments, and that the principle of equal pay for equal work is not principle which courts may recognize and act upon. We have shown that the answer is unsound. The clarification is irrational. We therefore allow the writ petition. So, my lord, these are the initial judgments of the
this
Supreme
judgment,
Court.
The core contention of the respondents is that the sources of
Yes,
recruitment.
I'm precisely on that now. No,
This-
this is an authority, my lord. Source of recruitment cannot be the basis.
No, this is not an authority. No, source of recruitment with regard to vis-a-vis regular sanction post and non-sanction.
Non-sanctioned.
Here the question is not perhaps
Now here, my lord, it was not a case of
not a
sanction,
case of
non-sanction.
sanction,
It
non-sanction.
was generally.
General.
The Delhi police
Whether
drivers
the
are getting less.
Driver doing a job here and doing
And
there.
yes.
Whether they
And in our case also, my lord, there is no denial that we do the same work.
No,
There is absolutely.
that's not right. There is no quarrel on that.
Yes,
The core contention is that they are not, they are contractual work.
yes. So therefore, whether on the basis of source of recruitment, equal pay for equal work can be denied. Answer to this is the present decision, my lord. 1987, 4 SCC 634.
1987,
1987, 4 SCC 634. Paragraph 11 at page 641. Here. Kunjan. Okay. Has the lordships got it, Miller? Para 11.
Bhagwan Das.
Bhagavan Das. With regard to the next contention, that the mode of recruitment of the petitioners is different from the mode of recruitment of respondent number 2 to 6, we are afraid it is altogether without substance. The contention has been raised in the following terms, that is paragraph 4D of the counter affidavit dated so and so. It is absolutely incorrect that petitioners are similarly placed as employees under the social education scheme as alleged. The latter are whole-time employees selected by subordinate service selection board after competing with candidates from any part of the country. In the case of the petitioners, normally the selection at best is limited to candidates from cluster of a few villages only. The contention made by the petitioner has no justifiable basis. So precisely the same stand as here. We need not enter into merits of the respective modes of selection, assuming that the selection of the petitioner has been limited to cluster of a few villages, whether respondents number 2 to 6 were selected by another mode wherein they had faced competition from the candidates from all over the country. We need not examine the merits of these modes for the very good reason that once the nature and function of the work are not shown to be dissimilar, the fact that recruitment was made in one way or the other would hardly be relevant from the point of view of equal pay for equal work doctrine. It was open to the state to resort to a selection process whereat candidates from all over the country might compete, and if they so desired. If, however, they deliberately choose to limit the selection of candidates from a cluster of a few villages, it will not absolve the state for treating such candidates in a discriminatory manner to the disadvantage of the selectees once they are appointed, provided work done by the candidate so selected is similar in nature. So there is a caveat, it has to be similar. It was perhaps considered advantageous to make recruitment from the cluster of a few villages for the purpose of adult education scheme, because supervisors appointed from that area would know the people. And these are the facts of the case. So, my lord, mode of recruitment cannot be a basis for denying equal pay for equal work. So, this is an direct authority on the point. I'll place two more judgments, my lord. One is 2008 1 SCC 586. 2008 1 SCC 586. Paragraph 12 and 13. At page number 591. The principle, as a lordship's got in it. I'm sorry.
Paragraph 12 and 13.
Yes. At page 591. The principle of equal pay for equal work has been considered, explained, and applied in a catena of decisions of this court. The doctrine of equal pay for equal work was originally propounded as a part of the directive principles of the state policy in Article 39D of the Constitution. In Randhir Singh versus Union of India, a bench of 3 judges of this court had observed that principle of equal pay for equal work is not a mere demagogic slogan, but a constitutional goal, capable of being attained through constitutional remedies and held that this principle had to be read under Article 14 and 16. This decision was affirmed by Constitution bench of this court in D.S. Nakara. Thus, having regard to the constitutional mandate of equality and inhibition against discrimination in Article 14 and 16 in service jurisprudence, the doctrine of equal pay for equal work has assumed the status of a fundamental right. Initially, particularly in early 80s, the said principle was being applied in an absolute rule, but realizing its cascading effect on other cadres, in subsequent decisions of the court, a note of caution was sounded that principle of equal pay for equal work had no mathematical application in every case of similar work. It is observed that equation of post and equation of pay structure being complex matters are generally left to the executive and expert bodies like pay commission. It has been emphasized that a carefully evolved pay structure ought not to be ordinarily disturbed by the court, as it may upset the balance and cause avoid ripples in the other cadres as well. Nevertheless, it will not be correct to lay down an absolute rule that merely because determination and granting of pay scale is the prerogative of the executive, the court has no jurisdiction to examine and the pay structure, any pay structure, and an aggrieved employee has no remedy if he is unjustly treated by arbitrary state action or inaction, except to go on knocking the doors of executive or legislature, as it ought to be canvassed on behalf of the appellants. Undoubtedly, when there is no dispute with regard to qualification, duties, responsibilities of the persons holding identical post or rank, but they are treated differently merely because they belong to different departments or on the basis of classification of posts, is ex specie irrational, arbitrary, unjust. It is open to the court to intervene. So, my lord, this is a judgment which has taken a very balanced view. Unlike the decisions in the 80s, my lord, where in absolute form the rule of the doctrine was applied, now certain cautions has been given. But having given so, my lord, it says three things. Identical posts or rank, with regard to qualification, duties and responsibilities of the persons holding identical posts. So these are the three relevant considerations. Now finally, I'll rely on one more judgment, my lord, that Jagjit Singh's case, 2017, 1 SCC 148. My lord, in fact, paragraph 42 is the operative considerations, my lord, which was taken note of by the Supreme Court, Honorable Supreme Court. Now, entire gamut of the matter was gone into para 42 at page 205.
Yes.
All the judgments noticed in paragraph 7 to 24 herein above pertain to employees engaged on regular basis who are claiming higher wages under the principle of equal pay for equal work. The claim raised by such employees were premised on the ground that the duties and responsibilities rendered by them were against the same post for which a higher pay scale was being allowed in other government departments. Or alternatively, their duties and responsibilities were the same as of the other posts with different designations, but they were placed in a lower scale of pay. Having been painstakingly taken through the parameters laid down by this court, wherein the principle of equal pay for equal work was invoked and considered, it would be just and appropriate to delineate the parameters laid down by this court in recording the said parameters. We have also adverted to some other judgments pertaining to the temporary employees, wherein also this court had the occasion to express legal position with reference to principle of equal pay for equal work. Our consideration has led us to the following deductions. the onus of proof of parity in duties and responsibilities of the subject post with reference to the post under the principle of equal for equal lies on the person who claims it. So, my lord, onus is upon the petitioners to establish. 1. 2. The mere fact that the subject post occupied by the claimant is in a different department, the reference post does not have any bearing on the determination of the claim under the principle of equal pay for equal work. Persons discharging identical duties cannot be treated differently in the matter of their pay merely because they belong to different department of the government. So, my lord, this is a paragraph where the Honorable Supreme Court dealt with the cases of persons working in different departments. 42.3. Principles of equality, equal work for equal play applies to cases of unequal scales of pay based on no classification or irrational classification. Then Milord will kindly come to 42.4. Person holding the same rank designation in different departments but having dissimilar power, duties and responsibilities can be placed in different scales of pay and cannot claim benefit of principles of equal pay for equal work. Therefore, principle would not be automatically invoked merely because subject and reference post have the same nomenclature. So, nomenclature is not decisive. Now, in my humble view, my lord, 42.5 is very important. In determining equality of functions and responsibilities under the principle of equal pay for equal work, it is necessary to keep in mind that duties of the two posts should be of equal sensitivity and also qualitatively similar. So, which in our case it applies. So, my lord, this is how the court dealt with it. Then, my lord will kindly come to para 45. There are other situations also envisaged. Para 45, my lord, we shall now attempt an analysis of the judgment wherein this court declined to grant benefit of equal pay for equal work to temporary employees in claim for pay parity with regular employees. So, my lord, court also dealt with the situation, cases where court has declined. Then, my lord will kindly come to paragraph number 60. Sorry, 57. In fact, para 56 at page 222, we shall now deal with the claim of temporary employees before this court. There is no room for any doubt that principle of equal work for equal pay for equal work has emerged from an interpretation of different provisions of the Constitution. Principle has been expounded to a large number of judgments rendered by this court and constitutes a law declared by this court. The same is binding on all courts in India under Article 41 of the Constitution of India. Parameters of principles have been summarized by us in para 42 herein above. The principle for equal pay for equal work has also been extended to temporary employees, differently described as work charge, daily, wages, casual, ad hoc, contractual like. The legal position relating to temporary employees has also above has been summarized by us in para 44. The above legal position, which has been repeatedly declared, is being reiterated by us herein again. In our view, it is fallacious to determine artificial parameters to deny fruits of labor. An employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities. Certainly not in a welfare state. Such an action, besides being demeaning, strikes at the very foundation of the human dignity. Anyone who is compelled to work at a lesser wage does not do so voluntarily. He does so to provide food and shelter to his family at the cost of his self-respect and dignity, at the cost of his self-worth, and at the cost of his integrity. Further, he knows that his dependent would suffer immensely if he does not accept the lesser wage. Any act of paying less wage as compared to other similarly situated constituents an act of exploitative enslavement emerging out of domineering position Undoubtedly, the action is oppressive, suppressive, and coercive as it compels voluntary subjugation. Now, my lord, at para 59, it adverts to the international covenants, that is, rights of 1966. Eventually, Lordship will kindly come to para 60. Having traversed the legal parameters, with reference to application of principle of equal pay for equal work in relation to temporary wages employees, daily wage employees, ad hoc appointees, employees appointed on casual contractual employee and the like, the sole factor that requires our denomination is whether the employees concerned before this court were rendering similar duties and responsibilities as were being discharged by regular employee holding the same corresponding post. This exercise would require the application of parameters of principle of equal pay for equal work as summarized by us in para 42. Then, my lord, may kindly skip the middle portion. Please come to placitum E. There can be no doubt that the principle of equal pay for equal work would be applicable to all temporary employees concerned, so as to vest in them right to claim wages on par with the minimum pay scale of the regular engaged government employees holding the same post. In view of the position explained by us in the foregoing paragraphs, we have no hesitation in holding that all temporary employees concerned in the present bunch of cases would be entitled to draw wages at minimum of the pay scale extended to regular employees holding the same. I think, my lord, after this judgment, which is of 2017, after taking note of all the parameters laid down by the Supreme Court, my lord, I think the petitioners have a case for your lordship's kind consideration. This is my humble submission. My lord, with your lordship's kind permission, can I take leave, my lord?
Lordship may kindly turn to page 123 of the report. Page 123.
123.
Yes, sir. Lordship will see the amendment number 528 is the last writ petition amendment.
Writ petition.
Yes, 528. Now, my lord, in para 2, they say that, my lord, they are working as, my lord, A&M nurses and were engaged between 2006 to 2015 in various health sub-centers, in the various districts of Assam. Not a single statement has been made, my lord, that they were appointed by the respondent number 1 and 2 in the writ petition. But we will kindly turn to page 123 again.
So they are working. Where
No,
are they
no,
working?
that's why I will point out, my lord, that official respondent in the health department is commissioner and secretary and the director of health services. Finance, my lord, is not the appointing authority or at all, my lord, concerned department.
You represent who?
I appear for all, my lord. Why I'm pointing out is that lordship will now turn to page 135 for a moment.
135.
Yes, Annexure A starts, my lord. Lordship will see, my lord, at the top, Office of the Member Secretary, District Health Society, Gulaghar. Order for contractual engagement of A&M. Now, lordship will see the engagement order. Here, lordship will find, my lord, the last third line. The date of joining in the post, comma, subject to execution of the terms of contract. And lordship will see who has issued the appointment letter. Member Secretary, District Health Society and Joint Director of Health Services. Lordship will see now, my lord, page 123 again, whether this authority is a party in the present proceeding. And lordship will see is a member secretary of a society, whether they are party headed. Now, lordship may turn to the next page, my lord.
These salaries are paid by whom?
That's why, my lord, unless and until the authority comes up, the registered society, they get some, my lord, grant from the government, and my lord, they used to collect revenue from themselves, from various hospitals, my lord, that, my lord, patients are admitted, some amount is given. From that, this amount is paid. Until and unless they are made party in the present proceeding, how can, my lord, this honorable court decide, my lord? That's why the director has said, my lord, I am not the appointing authority.
They have raised this objection before the arguments were made. you are questioning the.
No, it will have to be, my lord,
eventually you are
when
questioning the maintainability.
when my time comes, well, I'm making my submission,
It is all
because
right,
I
but
understand.
you
That's
are
why I point
raising-
out, my lord, 528,
You are raising the question of maintainability.
it can be raised, my lord.
Essentially on merit.
No, it's in the admission phase I am
No,
raising it.
no, we are not
My
denying
lord,
that
yes,
you
yes.
cannot
Before
raise.
the argument on merit was
What
made.
we are saying is that
Lordship, that's why
the
I'm saying,
reply has to be there from
no,
the senior
my lord,
counsel.
they have been repeatedly, my lord, referring to various paras of our affidavit. The director has said that I am not the appointing authority, I can't say. Now, Lordship will turn to the other pages just for a moment, my lord. Page 137, it is again the member secretary. 138, my lord. 139, it is the mission director, National Land Mission, not a party. And my lord, they have only as a sample copy, 4 or 5 appointment letters have been placed. Not a single statement in the writ petition regarding their present place of posting. How can someone say whether they are working in what post and what is their present duties and functions? Well, nothing is there. 528 writ petitioners have jointly preferred the writ petition. For a common cause, they can, but at least their particulars should have been placed. And their appointing authorities should have been made party, Only they can say whether they are working or not. And whatever averment has been made in the writ petition is against the department. Nowhere they have made a categorical statement. It is the respondent number 1 and 2, or the respondents have made their appointment. Lordship will see para 2. It was read over by the petitioner's side.
Hmm.
It says, my lord, may I read it once, my lord? The petitioners are presently serving as A&M and midwife on contractual basis in different districts of the state of Assam, not under the state government. The petitioners have completed required training course to be qualified to practice as an A&M. All the petitioners have been appointed as A&M on contractual basis between 2006 to 2015 at health sub-centers in various districts of Assam. The petitioners were appointed in the said post pursuant to a valid selection process. The petitioners have filed the instant writ petition before the Honorable Court, being aggrieved by the impugn action of the respondents in denying the petitioners to draw the regular salary. But, my lord, where is the
But let us understand. These nurses, as you say, are appointed by society. Some
it
society.
appears so, my lord, yes, from 1 or 3
They
documents.
are meant to be employed where?
My lord, they will be working, of course, in a, my lord, particular sub-center, in a hospital, wherever their posting is given. But, my lord, the issue will be,
Where the nurses appointed by the government also work.
of course, my lord. Now, my lord, in order to give an effective order, supposingly Lordship finds that, my lord, they are entitled for the minimum of the pay scale or the equal pay, then who will have to implement that order, my lord? Unless and until the appointing authorities before this Honorable Court, the appropriate authorities before this Honorable Court, or the proper parties before this Honorable Court,
Who are here?
only, my lord, the director, the commissioner, and finance department. Lordship will see page 123. That's why the director said, my lord, I am not the appointing authority, I don't know. To give an effective reply to their averment, or even to consider, my lord, their own, my lord, grievance by this Honorable Court, the proper party will have to, the necessary party will have to be before this Honorable Court. Government may be a proper party. But, my lord, the NSM, my lord, there is appointment letter, they have annexed. Is not a party. The member secretary of various, my lord, district health societies, Lordship will see the term, it is a society, is not a party. 528 writ petitioners are there, my lord. Not a single averment, my lord, where they are working. They should have given a chart also, my lord, placing that this is the appointing authority and this is my place of posting. At least we can ascertain whether they are working or not as on date, and what is the duties and functions they are performing. Nothing is there, my lord. So blindly, my lord, the director has rejected it because he is not the appointing authority. There is nothing to show that he is the appointing authority. And on top of that, my lord, this is one, my lord, regarding the maintainability. Not on the maintainability, if they want, they can always impede it, my lord. Secondly, my lord, regarding the granting of minimum pay scale to the contractual employees or, my lord, the casual workers or, my lord, workers or master workers, the division bench of this Honorable Court has already passed an order in Upenda's case, my lord. This is holding the field. At least this Honorable Court is binding, my lord, that judgment is binding on this Honorable Court. Following Jagdish Singh, there the Honorable Court has laid down 2 conditions, my lord.
No, that is about regularization.
No, finally, my lord, regarding minimum of the pay scale, that order has been given.
Minimum of the pay scale was different. On a concession, if I can say so, made by the state. that we will give them the minimum of.
No, my lord. Board has said, my lord, we will not be terminating them, and we will give them the health facilities and all.
What was
The
issue?
direction of the honorable court was
What was the issue before the division bench? Division bench was that they were claiming for regularizing, not a case for regularizing. This is the case where they are saying that we are doing the same work.
but my lord, at least, my lord, there is a direction, there is a notification of the government in the finance department that, my lord,
That is it. That has to be read in terms of the judgment is what it decides.
lordship.
You
Instead
can't-
of
you can't pick up
regularization,
a
the
line
minimum
from-
was
from
pay of,
one judgment and apply it, make it for university. Judgment is an authority for what it decides.
my
What
lord,
did it decide? Whether the petitioners to the division bench had a right
to be regularized.
to be regularized. That the court said to be found.
But they will be entitled for, my lord, the minimum of the pay scale. That is the direction given by the division bench,
In
not by the
respect
state,
of
my lord.
people
Not
who
by
are claiming
commitment.
regularized.
Even then, my lord, the status is same, my lord. And following Jagdeep Singh, my lord, this order has been, that our direction was given.
This thing has not a, it saying is not an authority only for that. There are many other.
Yes. In fact, my lord, various judgments have been relied upon, then it has been reiterated in Jagdeep Singh, I would
But
say.
it has-
Yes,
it is not an authority for that.
my lord.
But here is not a case for regularized.
So that's my submission, of course, my lord. In
The
that
case
angle,
where
my
they are
lord, of
saying
course,
that
this
we
will be a
want to
different
given the case.
instead of regularization, my lord.
Now in view of the.
No, my lord, one more thing, my lord. It's a different thing that a particular person is working on contractual basis. It's another thing that a contractual employee, after signing a contract agreement, enters into service. In the present case, whatever one or two documents they have placed, there is a contract agreement. Moment contract agreement comes, the issue will be different, my lord.
You
No, how can, my lord, we are not the importing authority? That's why I'm saying, my lord.
you show us from the authority.
That, my lord, some authorities on this point, I will place, my lord. Any day, my lord, convenient, but, my lord, this is a, my lord, major, my lord, lacuna in the present petition, my lord. That the concerned appointing authorities is not a party, at least not in, on representative capacity, my lord, at least one. And they will have to disclose where they are working, my lord. How can the relief be given tomorrow, my lord, if an order is passed by this honorable court? Without disclosing where they are working, how they will get the, but this is not a prayer that they are seeking in RAM. It's in personam. They pray that they should be given. Not an association or, my lord, some registered society. They are claiming it in personam. So they will at least have to disclose their identity, my lord, where they are working, who is the appointing authority, where is the terms and condition, at least on one appointment, my lord, letter, along with the terms and condition. The status will be different, my lord, otherwise.
What do you
Any
say
day, my lord,
about
convenient, my
non-joinder?
lord. On that part, we will apply, my lord. Legal issue, my lord,
What
otherwise.
do you say about non-joinder?
Actually, we can do one thing. We can file an additional affidavit about all the petitioners where they are currently working.
My lord, unless and until the parties, my lord, appointing authorities are party, how can they, my lord, contest the case? Because burden will be upon them. The society tomorrow, whether they will be able to pay or not, whether they at least entitled to pay or not, my lord.
Because all of
That
them are
opposite-
working right now, Your Lordship. So we can place
And
an
including
additional
NSM, my
affidavit.
lord. It seems, my lord, and lordship will, my lord, one more point, lordship may indicate in the order, page 150 for a moment, my lord. They have relied upon a representation. Page 150 of Annexure C of the petition.
Yes.
Lordship will see 150 for a moment. This is the representation that they have annexed in the petition. Lordship will see, my lord, I will read only 3 lines. Page 150 Annexure C.
154.
150.
150.
Only 3 lines, my lord. With due respect and humble humility, the undersigned would like to inform your esteemed self that they are presently serving as A&M, general nurses and midwife, laboratory technician, pharmacists who are working under the National Health Mission on contractual basis. My lord, where NSM is a party or not in the petition, my lord. Apparently, my lord, one page 123 is very clear. Without making the concerned authority a party, whether an effective order can be passed or not. So even to implement the order.
Yes.
13 well, on 15th or 13 any day convenient. 13 minutes is not inconvenient.
13. Change already. By your name
Mohanta.
and more. Mr. B. Gogoi.
Keep it partner minute. Always.
By Mr. M. P. The matters have been heard at something for the hearing on 13th.
Right.
Matter to be treated as part of
Tito.
May it please your lordship. Lordship, this matter is relating to a process to verify the caste certificate. The other side has already completed. I am fully prepared with the case. One very important that the record maybe lordship would like to peruse, because the whole decision-making process, every note, what I propose that I'll place the whole file before this honorable court and a photocopy of the note sheet to the other side also. Otherwise, affidavit covers everything, but the decision-making process is not reflected in the affidavit.
the record is there.
Not-
Hard with the
Yes, today that record is not, because after going through everything, that record I have placed it before the review court also and before the contempt proceedings also. That record is not with the council today, and today is a holiday. That's why I could not bring the record. So if the matter is taken upon
But
8,
only one thing.
yes,
There is the division bench.
yeah, I'll come to that. Absolutely. How the division, that issue is very clear. The division bench judgment is based on a report of 3rd of October 2019. That report is very cryptic, very mechanical, and it does not contain the most vital facts and more on the judgments of the Supreme Court. I can place it also. That report is the basis of the learned single judge's order, and finally the division bench also, in the appeal filed by the third party, the same opinion has been given as the report is of 3rd of October 2019, and that report, it is very clearly said that the allegations are not based on truth. So that is the finality of the division bench judgment. Thereafter, and during that appellate period, the government wanted to file an appeal. I'll come to that. When the appeal was being prepared, the writ appeal was dismissed. So the government did not have the occasion to file the writ appeal. That the authority, that district level scrutiny committee, they passed the order to cancel the certificate. There were two reports. One report is of the circle office and the deputy commissioner's report, and the other is by the police officer. That is a vigilant officer. When the government took a decision, come to a conclusion that now we have to revoke the suspension, and government in its wisdom found that there are two opinions of two authorities of the government. One by the vigilant officer, that also belongs to the state government. The other authority, that is the circle officer. The circular officer's report cannot be relied upon by the state level scrutiny committee because in the case of Madhuri Patil, the vigilance officer's report is final. That is the opinion given in the Madhuri Patil's case. So the committee has relied upon the report given by the circle officer to give their finding that the certificate is liable to be cancelled. Government tried to find out whether the enquiry was done by the police officer was proper enquiry or not. Government directed the Home and Political Department to find out. The Home and Political Department found out that the enquiry is totally perfunctory, no proper facts were found out, no effort was there by the police officer to go to the roots of the matter. Thereafter, government filed a review application of the division bench as well as the learned single judge's order, which have attained finality at that point of time. And in the meantime, the CID, the second authority of the police department, inquired and come with a proper detailed report. That report is of 26th of December 2023.
What we wanted to know is, there was some report which was before the single judge
Yes,
answered it,
yes.
then it went to the
Division bench? Yes,
division bench accepted it.
yes.
Now, according to you, there were certain materials which were not,
Not there. That
Not
is
there.
why
therefore, does it not require a review of the division bench order?
I am coming to that. Let me just complete the facts. Then Lordship will put this query again. So, review was filed to have a review of the learned single judge's order as well as the division bench order with all the materials. And when all the materials come up before us, according to the Madhuri Patil, we have to give an opportunity to that lady, the writ petitioner. That notice was issued. So on 26th, we received the report from the CID with complete facts that she is not entitled to get the OBC certificate. And she was wrongly given. With facts, all I am trying to place. So the Madhuri Patil says that we have to give an opportunity. That notice was issued on 27th of December, which is put before this Honorable Court under this writ petition. They are aggrieved by that notice. In the meantime, review was also continuing. It was being heard by the division bench. So division bench put a query whether you want to pursue with that proceedings as per Madhuri Patil's, because law is well settled that we can go for a second enquiry also. If the enquiry is not properly done or the enquiry is perfunctory in nature or there is falsehood in the enquiry report. In that situation, Supreme Court in Shipra, J. Shipra's case very clear that we can go for second enquiry also. That we have done. After the enquiry is over, we have to give an opportunity for violation for following the principles of natural justice. So the division bench put up a question before us, whether we want to pursue the review or we want to pursue the enquiry under the Madhuri Patil's guidelines. That is so cause notice of 27. After instruction, we have decided to withdraw the review application as we are pursuing the proceedings under the Madhuri Patil's procedure. So we withdraw the review application because a fresh cause of action has arisen in the meantime after the CID's report came, and they have challenged the so cause notice issued in terms of the second enquiry. So that is the question before this Honorable Court. So earlier that report of 3rd of October 2019, on that basis, the division bench as well as the learned single judge passed an order. Now, subsequently, lot of new facts have come out. And if it was a established case that it was a perfunctory enquiry. So now whether we can pursue or not, whether we'll close our eyes and allow the undeserving candidate to take the benefit of OBC certificate, or we can reopen it and go accordingly as per the procedures laid down in Madhuri Patil's case. So that is the question. The Lordship will have to be satisfied that whether the earlier report was perfunctory or not, whether the second enquiry is correctly done or not. That is the question before this
on
Honorable.
the record.
That requires that affidavit. We have stated certain things, but the records, the opinion, how the government took the conscious decision to go for the second enquiry and start a fresh proceedings for verifying the certificate issued to the writ petitioner in terms of the 2006 notification. In the meantime, we have come with lot of dirty and very ugly facts.
Tell
Which-
us when record.
Records, in fact, on 8th of 8th, next Thursday. Otherwise, I can complete the whole facts, replacing the facts and making my submission.
Is 20 a date convenient for all of you?
This honorable. Meena, 20, 20.
20,
We'll do it, Lordship.
subject to continue.
Let us put it on 8th, Lordship. If it is not inconvenient, then if in inconvenience, then we can go to 8th,
8, 13, 15, all these several matters are fixed up.
Lordship. Then let it be on 20th. No difficulty.
We can fix it, but we can't say that we'll be able to take up the matter. Because the dockets are filled up.
Okay,
But 20 is available.
Lordship. No issue.
20,
So let it be 20th, 20. 20. Because ultimately, if I complete my submission, so I'll take about 1.5 hours to place
Yeah,
all the
therefore,
record. But the record will be required because in the record, it is very clearly revealed how the government took up this decision to go for this exercise subsequently done.
Therefore, we are fixing 20 so that we can have an exhaustive hearing.
Lordship.
on Monday.
Lordship, on 20th, there will be some difficulty on part of my senior.
And let him come, let him begin. Let him
Yes.
place the records and we see what it does.
Deeply obliged.
As agreed, had to be listed on 2020. And additional learned advocate general submits that the relevant records will be necessary,
Yes.
which are not available with him. Right? He therefore submits that had to be listed on 12th, which is the report can also be placed
Lord.
for perusal of the court. As per report, this matter again 2020
20.
May.
Highly obliged.
Thank you.
Worship, on the last date, the testimony number 2 has filed an affidavit that is very peculiar.
So,
What they have
additional
stated
affidavit.
is that in para number 3, that the deponent begs to state that while going through the affidavit in opposition, that means they have earlier filed, the deponent noticed a mistake in construction of a sentence, para 8 of the said affidavit, where it has been stated as, within inverted comma, the petitioner was transferred as a punishment in lieu of various complaints received. They are going to clarify that no, it was not a punishment transfer. In this context, the deponent begs to state that the word punishment has been unintentionally mentioned while preparing the affidavit on behalf of the present deponent, and the deponent also did not notice, superficially filed that means. And same, while sharing the affidavit in opposition, it is to be mentioned here that there were various complaints against the petitioner, repeating the same thing that we complained, but those were not heard, nor any explanation from me was invited or inquired. Then in next paragraph 4, this affidavit is shown by the deponent to clarify the mistake they have committed, the fact that there was no punishment transfer of the petitioner. Now, what they are going to mean by filing this affidavit? So there is the transfer itself is malicious, and if they are asserting that on the basis of complaints, I was transferred, That means they are acting on some extraneous cause. And in view of Supreme Court's judgment, as I have already submitted to Ms. Tiwari's case, I have a good case, so transfer order may be quashed.
What is the judgment you placed again?
Sumesh Tiwari versus Union of India. That is,
Can you give us the citation?
it is Civil Appeal number 7308 of 2008. Civil Appeal, Supreme Court of India. Sumesh Tiwari versus Union of India and others.
What is the number? 7?
The paragraph number 19 and 20.
No, civil appeal number.
Civil Appeal number 7308
Of
2008. SLP Civil number 3516 of 2007.
Do you have an extra copy with you?
I've already submitted earlier.
I don't know, it is not there in the file.
I have.
Lordship, yesterday we have filed one additional affidavit, Lordship. An inadvertent mistake, Lordship, one word was used while filing the affidavit, Lordship.
You should correct it by filing a miscase for removing it.
Lordship, that's why we have
Really?
filed the additional affidavit, Lordship. Is no copy too? Judgment to whom? Judgment to whom?
We got it.
Lordship, sorry to interrupt. Lordship, sorry to interrupt. Actually, this case, as Doctor will appear this case, but today he has some medical issues. So,
We had already heard this matter. Please read the judgment again. Read the judgment.
Lordship, in paragraph 19, indisputably an order
No,
of
no, you read from the, let us recapitulate. You can start from para 2. Para 2 of the judgment.
Yeah. I'm starting from para 1. A short but an interesting question that arises for consideration in this appeal is as to whether the High Court, while quashing an order of transfer passed against the appellant, was correct in directing that he would not be entitled to salary for the period commencing 15 days after the modified order of transfer to Ahmedabad was passed till the day he again joined his duties at the original site. Number two, the basic fact of the matter is not in dispute that appellant is an officer of Indian Revenue Service. He was posted as Deputy Commissioner of Central Excise at Bhopal. Three, inter alia, on the premise that the employees posted at the Bhopal office of the respondent apprehending disciplinary as also criminal proceedings at the hands of the appellant on the basis of the reassessment of the file undertaken by him. An anonymous complaint was made alleging cash bias on his part, pursuant whereto an order of transfer was passed against him on or about 22nd August 2005. Then, prior thereto, he had filed a representation stating that he had been undergoing some treatment. He should be retained at Bhopal. Appellant, however, contended that in view of the fact that he had taken action against some erring officers, they were instrumental in sending the said anonymous letter on the basis whereof no action should have been taken in the light of the circular letter issued by the Central Vigilance Commission. It is, however, accepted that an inquiry was conducted by the Assistant Commissioner, Directorate of Vigilance into the said anonymous complaint, wherein allegations made against the appellant were not found to be true, but still recommending were made that he be transferred from Bhopal. Only on that basis he was transferred to Shillong. He indisputably made a representation saying that on compassionate and humanitarian grounds he may be retained at Bhopal for at least 1 year. The said representation was not responded to. In the aforementioned factual backdrop, he filed an OA before the Central Administrative Tribunal, the Bolpur bench, which was marked as OA number 897 or 897 of 205 by an order dated 27 September 205, having regard to the fact that the representation filed by the appellant had not been disposed of by the authorities of the respondent. It was directed. Accordingly, we direct the respondent number 2 to consider and decide the representation of the applicant dated 29 August 2005, that is Annexure A5, and take a decision by passing a speaking detailed and urgent order within a period of 4 weeks from the date of receipt of copy of this order. Till the decision is taken by the respondent number 2 on the representation of the applicant, he will not be disturbed from the present place of posting. The learned counsel for the applicant is directed to send a copy of this order as well as the copy of the petition to the respondent number 2 immediately. By an order dated 19th August 2005, the said representation was rejected. Another representation was filed by the appellant on or about 25th October 2005, stating, I do not know whether any some adverse report were sent by this commissioner or by the chief commissioner office, because if there were complaints against me, those were neither communicated to me nor I was given any opportunity to hear. It was not be surprising if any adverse reports were sent against me in such an atmosphere of conspiracy against me. Hence, it is my humble prayer that if any reports were sent by this office of Chief Commissioner Office or Board or other forum concerned, file may be shown to me along with supply of copy of document, that is copy of the complaint, proceeding of inquiry report, etc. If no inquiry or complaint, that also be intimated to me through the letter so that I can prove my innocence before the honorable court. Within bracket, in case Brock turns down my representation in spite of direction given by K. Jabalpur, or before 28/10/2005, which is heard. As the said representation was rejected by an order dated 27th October 2005, the appellant filed another OA before the Central Administrative Tribunal, Jabalpur, being number OA 1042 of 2005. Then, indisputably, during the pendency of the said OA, respondent, while considering the matter of promotion, posting, and transfer in the grade of the Assistant Commissioner of Custom and Central Excise, as an order dated 28 December 2005, inter alia, transferring posting on administrative consideration, transferred the appellant from Shillong to Ahmedabad. An application for amendment of the OA was thereafter filed, which was allowed. The order under challenge before the tribunal were passed. The order dated 22nd August 2005, 19th October 2005, and 28th December 2005. Inter alia, on the premises that the appellant had not reported at Ahmedabad, and furthermore, that an order of transfer was an administrative one. The tribunal, by its order dated 14 March 2006, held. On perusal of the record, I find that the order of transfer is on administrative exigency. The applicant had all India transfer liability. An order of transfer should normally be issued and should not be countenanced by the tribunal, as though they are appellate authorities over such order, which would assess the niceties of the administrative needs and requirements of the petition concerned. This is for the reason that tribunal cannot substitute their own decision in the matter of transfer for the competent authorities of the state, and even allegations of malafide, when made, must be such as to inspire confidence in the court, or as based on concrete material, and ought not to be entertained on the more making of it, or on consideration borne out of conjecture or surmise, and except for strong and convincing reason, no interference would ordinarily be made an order of transfer. Since the applicant's request has been considered and he has been transferred from Shillong to Ahmedabad, even then, the applicant has not reported for duty at Ahmedabad, and he is still challenging the order of transfer, Annexure A1. The applicant has been transferred under the modified order, and the earlier order merged with the present modified order. The applicant did not honor the impugned modified order of transfer. Now, he is asking for recasting of the original order dated 22nd August 2005, including the modified order. I find there are no allegations against any impugned order of transfer. It is an administrative order. The authorities can extract service of the applicant wherever they want. When the action of the respondent is within their purview, I am not inclined to interfere with the impugned order. I consider the averment made in the pleading and also argument of the learned counsel for the party. I am of the considered view that there is no illegality or irregularity committed by the respondent while passing the impugned order. They have exercised their powers within their purview. The tribunal need not interfere with the impugned order. The applicant has not made out a case for grant of relief, and accordingly the OA is dismissed, no cause. That is the order passed by the learned administrative tribunal. Agreed by and dissatisfied therewith, appellant filed a writ petition before the High Court of Madhya Pradesh at Jabalpur. As during the pendency of the said writ petition, a disciplinary proceeding was initiated against the appellant on the premise that he had not joined the post at Ahmedabad. The High Court passed an interim order on 17th April 2006 directing, since the transfer of the petitioner to Ahmedabad is sub judice in this court, for the time being, disciplinary authority will not take any disciplinary action against the petitioner. The High Court, by reason of the impugned judgments and order dated 25th September 2006, while opining that the order of transfer could not be passed on the basis of an anonymous complaint, which on inquiry having been found to be incorrect, held, though when individually considered the impact of the correct mention of the fact that the petitioner belongs to Madhya Pradesh and does not know English in the order rejecting the petitioner's representation, except for indicating the extent of absence of application of mind by the respondent, is not fatal. However, the transfer of the petitioner on the ground that he apparently gave an impression that he worked on caste-bias ideology, in spite of the fact of recording a finding in the negative in the discrete inquiry conducted into the anonymous complaint, would shock the conscience of any reasonable man, to say the least. It was furthermore pointed, as the allegations of having caste bias were not found to be true, the order of transfer having been issued by way of punishment was unjustified, stating it is no doubt true that the petitioner or other member of an all India service can be transferred to any place, country, and is obliged and duty bound to comply with the same, but to transfer him on the ground that some unidentified colleague felt that he is a caste is, in other words, only because he belongs to a particular caste, is in violation of his fundamental right under Article 14, 15, 1, and
Just
16.
1 minute. Government Council, do you have the records?
Save me, with the panchayat.
Panchayat, do you have the records?
Lordship, earlier record was called for, but they have not put it. There is an
The
order.
records will reveal whether it is a transfer on punishment or not. And your affidavit was filed by one Sanjeev Kumar Bora.
Lordship,
Earlier.
he has filed an additional affidavit also
Ah.
stating this fact, Lordship. Inadvertently, Lordship, this word has been used, Lordship,
This new affidavit.
new affidavit, Lordship, and he did not notice while signing this affidavit, Lordship.
Sorry, not Sanjeev.
So this was unintentional, Lordship.
No, not Sanjeev Kumar.
Kumar.
Who is Ashwini Kumar Dole? Who issued the transfer order?
Deputy Commissioner.
Deputy Commissioner,
Deputy Commissioner.
Lordship.
Is the no, these are personal posts.
But
Lordship,
Can it be transferred?
Lordship. DC has the power to transfer within their district.
No, transfer, yes.
Lordship,
But this man is working in a post which
Right.
is personal to him. Meaning that once he retires, goes away, the post is abolished.
Lordship.
Now you are transferring him to somebody, some other post. Are you transferring the person or you're transferring him with the post?
Transferring within the post.
Where is that order?
Actually, Lordship, in this matter, as Dr. will appear, but he is not available.
See, that benefit of adjournment you get only for a senior counsel. Otherwise, you are an advocate on record. If he is not there, you are there, you have appeared, that you have to argue the matter. You are also a standing counsel.
Lordship.
That-
But
The purpose of government counsel is to assist the court. The abode duty is not to take adjournments on every date, on one pretext or the other. Where is that transfer order? Impugned order? Lecture one.
Page number 17 in our read petition, Lordship.
17.
17. And extra two. My name is appearing at serial number 15. All are regular employee except I'm a casual, that is mentioned.
The transfer order does not clarify whether he is transferred along with the post. You get the file, get the records. We'll have to go through the records in view of the affidavit file, that it is not a punishment posting.
Lordship, that is what I just want to clarify one thing, Lordship. There is a notification by the Governor of Assam, Lordship, of 2021. Where is Lordship, the District Commissioner of all districts, is empowered to transfer and post any employee, grade 3, 4, Lordship, for proper administration of the district with consultation with the head of the particular department, Lord. So this is their Lordship, this notification is there.
No, the question is not whether DC has or it does not have the
Lordship.
power. Question is whether it was issued on punishment.
No,
There
this
is
is
an
not in
affidavit.
we have the clear instruction, Lordship. This was absolutely not a punishment, one Lord.
No, see, once you file an affidavit,
Lord,
that affidavit, where is that affidavit you have filed?
Lordship, yesterday, this is on record, Lord. Thank you, the record. On filed yesterday, Lordship, 30th April.
No, that is your additional.
Additional affidavit.
The
It is
original affidavit.
clarification. Earlier they stated that it is a punishment, and now they want to say
See,
that
you come to your original record,
Lord,
original affidavit.
Lord.
It was filed on 7 January.
Yes, Lord.
Come to para number 8.
Yes, Lord. Yes, Lord.
There is a clear averment that it was
Yes.
on punishment.
Yes, Lord.
Now you come to page, para number 15. Para 8 is sworn in as matters of record.
Lord.
So record will mean that in your official records, there is something which says that it is by way of punishment.
Then Lordship may clarify to the record, Lordship. I think
Learned Council parties. The matter was heard earlier and was fixed today for passing orders. So the Government Council, which I'm checking, with permission of the court, has had government council had filed an additional affidavit in opposition on 30th April, and with the permission of the court, same was brought on the court. The additional affidavit, you right there. The government had earlier filed the respondent number 2, namely the DC, Sipsagar, had earlier filed an affidavit dated 7th of January 2025, where at para 8, there is an averment that the petitioner was transferred as punishment in lieu of complaints received against him within courts. There is an averment inter alia, so and so within courts. The additional affidavit filed on 30 April by the same deponent, the CEO of Sagar. Now you are the chief executive,
Presently, he is CEO.
not DC,
Not.
who is presently discharging his duty as chief executive officer, Sagar's Dilapur Sagar, has filed his affidavit clarifying at para 3 that the averments made in para 8 of the earlier affidavit, within bracket, i.e. affidavit in opposition on behalf of respondent 2, filed on 7 January 2025, 22. The word punishment within courts was unintentionally mentioned while preparing the affidavit, and the same was not noticed while swearing the said affidavit in opposition. So, para. In view of the affidavit filed, the paragraph in question, namely para 8 of the affidavit in opposition dated 7 January 2025, which was filed by the deponent Sri Sandeep Kumar Bora in his capacity as the Deputy Commissioner Sipsagar, was sworn in as the paragraph number 8 was sworn as matters of record within courts. In view of the additional affidavit in opposition filed on 30 April 2025, where the said deponent made an averment that the term punishment within courts mentioned in para 8 of the affidavit in opposition filed by respondent on 7 January 2025 was due to inadvertence / mistake. This court is of the view that the relevant records where orders of the orders impugned in the present petition has been passed by the department would be necessary for perusal. Let the respondent. What is the record? What is the file number? Page number 17, come to the writ petition. Page number 17. On the top left hand side, is that the file number?
No. Lordship.
That is the file number?
SZP 7,
All right.
Lordship.
The file number is reflected in the impugned order dated 15 June 2023, which reads as liquidity book number, page number 17 of the top left-hand side, SZP. Let the record be produced before the court on 6th.
Because election process is going on.
Election, you have filed this in spite of the election process.
No.
It was filed on 30.
Lordship, Lordship,
6th. Matter be listed on 6th, on which date the relevant records be placed before the court.
okay.
Copy of this order be marked to the Session Council appearing for the department, namely MS N. Bora, for onward communication.
Lordship, in this case, record has been received by the D. Upamanyu, the council. Today, he is not absent, not present, Lordship.
Why?
So,
High
Madam,
Court is functioning today.
he has requested me to take time because he has some medical issues today.
All right, you get it on 6th
Lordship,
on a request made by on behalf of Mr. D. Upamanyu, Standing Counsel,
Health Department.
Health Department, that the records connected to the case are available with him. The matter stands referred to be listed on 6th. Mr. Manaf, K. Manaf, appeared.
Obliged, my lord.
Petition.
May I please, your lordship? This is regarding family pension, lordship. They are saying that I'm the second wife, but first wife is not surviving, lordship. But from our wedlock, lordship, there is a minor son, lordship. He has his right over family pension of his father, lordship. He's only 9 years old. It is difficult for him survival, lordship, along with his mother.
Your husband was receiving pension.
No, lordship. Prior to receiving
expired.
pension, he expired. The other benefits, son of his first wife, from his first wife has taken. The petitioner has no grievance because he is the son, lordship. But petitioner was expecting some family pension. Now they are saying that since she is the second wife, but I have a son, lordship. He has his share upon his father's family pension, lordship. That much, if possible, that aspect may be considered, lord.
So who will consider it?
My lord,
Why? It is a matter of fact.
lordship. I have annexed the birth certificate of the son, lordship.
It is for the department to consider it. Yes, Mr. Bora.
Let them take instruction regarding the son's share, lord.
What instructions are necessary? He is entitled to that.
He's
You are
entitled.
employed
What
under
had happened, my lord?
You are
Now,
employed under which department?
GMC, man.
GMC.
GMC. So
GMC.
government of Assam.
Now, there is a special,
Notifications will
they have a
apply.
special act, my lord. It has come into from 2014, my lord. Initially, when the first wife was surviving, he entered into marriage in 2014, and the first wife has expired in 2016. And the first wife, son has,
While he was in service,
while he was in service,
his first wife expired.
no, when he is the husband was in service, he was already married, and the first wife was surviving. He entered into marriage during the existence of the subsistence of the first wife, the first marriage. So that was that second marriage, when the existence of first wife, that is void.
How do you,
He himself has statement in paragraph number 3, my lord. In paragraph 3, he entered into solemnized into marriage in 2014.
yes.
And my lord,
Son was born in 2015. Now he's minor, lordship. Page number 21 is the birth certificate, where it is reflected the deceased government servant was his father.
And my lord, my affidavit, lordship will take up my affidavit, my lord. Here the first son of the first wife has already taken out a succession certificate. Herein there is a letter, my lord, in page number 59, my lord, where he clearly states that first wife, this is her mother, Maloti Das, has expired on 27/2016.
You're referring to page number?
59.
59, my lord. The son has already taken the succession certificate. Son of the first wife has taken a succession certificate. Lordship will see the succession certificate starts from page 43 to 56, my lord. Already succession certificate, he has taken out a succession certificate, my lord.
These are regarding other benefits of retirement benefits.
43.
43 onwards, my lord. He has taken out a succession certificate and all the other benefits. He had already taken it, my lord.
Except pension.
Except pension.
Pension is not here.
Pension is not here. Thereafter, my lord, I am only showing that the marriage with the petitioner has entered during the subsistence of the first wife. Because
No, that is okay.
that
But
is okay.
if
Then
the son, if the son is
son is
not,
okay, and then
Then he is entitled.
even if the son is not eligible born, my lord, he or she will be entitled for the
that's right.
pension.
He's
So you
here
take a
only.
call on
Lordship.
that and pass necessary orders. Is the first wife's son also a party?
No,
No,
Lordship,
no.
petitioner has no grievance against him. He has taken that much.
That is
You
one of
have
the
no
issues.
grievance, but he may have a grievance against your son.
That is my preliminary
That
objection I have
person
taken, my lord.
Lordship,
claims to be the only legal heir of the late father.
Lord.
Perhaps.
Lordship.
Had your son been shown also as a legal heir?
No,
then
no, no.
No,
Not shown.
not so.
No.
Where is the legal heir certificate?
Lordship, I have a next to kin certificate. Lordship, that is at page number 19 onwards, 20 is the relevant portion. Then he was only
Is there any
40.
specific pension regulation?
Yes, there is a specific pension regulation
Yes.
of the GMC which has come into effect from 2015. It is called Guwahati Municipal Corporation Employees Pension Regulation 2015. Madam.
Can we have a copy?
Have a it is voluminous. I have the extract of the copy.
All the more reason why you should supply sufficient copies to the court.
Well, I have it one, my lord, but exactly that particular portion, my lord.
Yes.
Petitioner is paying only his portion, Lordship. Nothing, entire family pension he's not claiming. He's not claiming.
GMC regulation.
Lord, this is letter, my lord.
Or you
It's a
want
big volume, more
or do
than
you want
100
a
pages.
judicial order?
No, Lord, I will produce. Because I have taken out the extract of that particular under family portion. Oh, it.
I have the entire.
And yeah, he has the entire one. It starts from Rule 55.
I have the entire copy.
Yes, he has the entire copy.
Family plan.
Hello, I
There are those line of judgments where
Yes, there are.
a child born out
Child
of
born out of
marriage
it.
is entitled.
Today I don't have it.
So that is the problem. You appear in court and you don't come prepared. You want everything to be done by the court for you. We refer to members of the bar as learned counsels. So you not only have to be learned, but you must also show that you are learned.
There are multiple judges.
Come back tomorrow.
Tomorrow I have some difficulty. Monday, Lord.
All right, Monday.
Lord.
List on Monday. At the request made by the council. That is for the DMT.
Deeply obliged.
Your Lordship, before starts my banner senior, Your Lordship. Your Lordship, in this matter, records will be required. Possibly record will be required in this matter, Your Lordship.
If it is required, bring it.
Lordship, some time may be given for it.
My lord, here, I know,
What is your grievance here?
my lord, here the very charge sheet, starting from charge sheet, my lord, so kindly come to charge sheet portion first. Page 20, annexure B.
Annexure?
Annexure B, my lord, page 20, this is the charge sheet, my lord. Here, the allegation is 10 lakh to total alleged misuse 10 lakh 11,576. And my lord, along with the charge sheet is invariably required to furnish list of the witness and document. Your lordship kindly come to now, my lord, to deal with this charge sheet. Rule 9(2) of the 64 rules, my lord.
No, did you not ask for the documents?
It is, my lord, since it is provided, may I read, my lord? Serial person. Rule 9(2), my lord. The district authority shall frame definite charges on the basis of the allegations on which the inquiry is proposed to be held.
Service.
Rule 9, my lord.
Yeah.
That is the procedural process.
Yeah.
Held such charge together with the statement of allegations. That is also missing, my lord. The statement of allegations is only one line on which they are based. Shall be communicated in writing to the government servant, and he shall be required to submit within such time as is specified by the district authority a written statement of his defense, and also to state whether he desires to be heard in person. Now, this rule was amended, bringing in, my lord, that at the time of delivering the charges, the district authority shall invariably, I need to ask, invariably furnish to the government servant a list of documents and witnesses by which each article of charges is proposed to be sustained. That was not provided. On this matter, your lordship is aware, my lord, that 1987 division judgment of this court, Madhav Das versus State of Assam, where on that count only the entire proceeding was quashed by the civil bench. I have given the list of books. Then my lord comes after that.
But you filed an appeal before against the judgment, against the order.
No.
No, because order was passed by the government.
But there is an appeal here.
Appeal against the order of suspension, Your Lordship. So far as the
Appeal against suspension.
only that, Your Lordship. Otherwise, the other
2013.
he never exhausted that.
Now his man has retired, my lord, last year.
Where is the order?
Order is, my lord, page 48. Annexure K to the petition. Here is the order dated passed by the Honorable High Court, because they had not completed the proceeding for a long period of time. Then we approached this court, and this court directed them to complete it within 2 months.
You did not raise this issue before the court earlier.
My lord, which is legally bound. I need to raise one. It is
Of course
their
you have-
duty, and this court has
Come to
decided.
page number 44. Come to page number 44.
Yes, sir. My lord,
Come to
Declaring
page number 44.
yes,
Towards the middle, by way of this writ petition.
yes.
You see
This
that?
is a short
For
for
quashing of the
division.
departmental proceeding.
Though Respondent 5 had filed the affidavit to ensure nothing has been stated in the affidavit, this court on several occasions have directed the government advocate to obtain instruction as to the stage of department proceeding. Today, Mr. Hendick, learned government advocate, submits that the proceeding is at the final stage. Mr. Mohammed, learned counsel for the petitioner, submits that the petition was put under suspension of political pressure to ensure. However, the said MLA himself subsequently withdrew her complaint and certified the petition to be sincere. Referring the communication dated 1/3/2010 of the Finance and Accounts Officer, Office of the Additional Chief Engineer, Water Resources Department, filter addressed to the Joint Director of Panchayat Rural Development Department, Assam, annexed 12 of the petition. Learned counsel for the petitioner submits that no anomalies have been found in the record in respect to the petitioner. The communication further indicates that the further director Qatar has put pressure on finance and account officer to show some discrepancy in the record. Accordingly, it is stated that he has compelled to show some animals in the against the petitioner. Since the council made a statement before the court that the department proceeding is at the final stage, the court would not like to make any comment on the read of the contention raised by the petitioner or the in view of the above. The response 2 is directed to conclude the proceeding drawn up against the petitioner pursuant to so-called notice so-and-so or 2008 case within a period of 2 months from the date of receipt of the certified copy of the order. Response 2 number shall follow all procedure safeguards in before taking final decision in the matter. Needless to say that the petitioner continues to have grievance, it will be open for him to approve the approved forum international law. So this was the case. It was remanded.
It was remanded, but you had prayed for setting aside of the departmental proceeding, and you did not take up this ground, perhaps.
So here the motion says after notice issued, it was immediately remanded back.
No, no,
All the
whatever it is,
contestants, it was last week seen the order.
the doctrine of the principle of res judicata is also applicable in
Applicable, my lord. That's why
constructive res judicata.
that's why this court gave the liberty to approach the forum.
No, liberty is all right. You challenge it on other grounds, but on the ground that it was never complied with, the documents were never submitted. It was available to you before. You did not say. You filed written statements. You did not raise this.
Not gone into my lord by the other court.
Huh?
Because on the instruction of the government, my lord, that proceeding is at the final stage, it was remanded, allowing them 2 months time.
Correct. You are now challenging this order on the ground that the mandate of Rule 9(2) has been violated.
9(2), 9(4), 5, 6, 7, all entire.
Correct. This was the position in before the court in 2013 also.
Yes.
You did not raise this objection.
Entire proceeding was put to challenge. Entire proceeding is put to challenge.
Correct. You challenge it on other grounds. That the witnesses were not examined, you were not given, or
Yes,
the
that
appreciation.
is what is the ground under my lord Rule 9. Lord's, may I read
No.
Rule 9?
What we want to say is Rule 9 ground is it could be a valid ground taken.
Yes.
No dispute on that.
Yes.
What we are asking you, the violation of Rule 9 was known to you in 2013 when you were before this court.
Yes.
When you challenged the proceedings. Why this ground was not raised?
My lord, before I could challenge, it was not reflected in the order. The proceeding was just going on. Then it was not finalized. It was not reflected in the order also.
You didn't see your written statement is there. You did not raise any objection that these documents were not furnished. You did not
But
file any
it-
application.
It's a record. The record shows that procedure was not yet followed. This is a legal point to argue. Then with the charge sheet itself will go. Not
See,
the,
We are not on this. We are on the passage of time. 2013, you had the opportunity. You did not do it. We are in 2025. After how many years? 12 years. You want after 12 years the order to be set aside and
No, but the writ is filed in 2013, my lord, not now.
No.
11. 2013 itself, I filed the writ.
yes.
This is a very old case, my lord. In the meantime, the man has retired, no doubt. He was reinstated and his sub full term has retired. Only now regarding pension and his other benefits.
What was the finding of this order?
Your lordship will have to go to inquiry. In inquiry report, my lord, the inquiry officer has.
You did not file an appeal.
Inquiry report is not furnished to me, my lord, but what is there?
Inquiry report not furnished.
Not furnished. Nothing was complied, my lord. Totally vague.
Inquiry report not furnished.
No.
Your lordship, yes. That is why I want to bring the records, your lordship. But it is marked in his name. It was marked. It is 49, page number 49, your lordship. 48, the
No, 48 is the order of the
order.
disciplinary authority.
Inquiry report.
Inquiry report. That is the
Or was
instructions you
it-
were asked to bring.
I have stated.
Yes, that is why your lordship, the record will be required. Whether
You only have to tell us whether the inquiry report was given to him or not as per the record. That's all.
yes,
So you get your records on Tuesday.
your lordship, this is the very old matter, your lordship. At least
So
one week time.
therefore, because it is an old
Kindly
matter,
see, your lordship, on subsequent dates, your lordship, petitioner failed to appear in this matter. That is why matters was once.
Once dismissed for default,
Dismissed
for
for
our default
default.
money, it was restored. Those cannot help him. This is not the matter to be argued in the, when case is being argued on merit.
you have filed your affidavit.
Affidavit
Yes,
was,
they
it
have
was
admitted-
filed in 13 itself. your lordship.
Almost admit everything.
2013 itself, the affidavit was filed.
Yes.
That's why your lordship, the
They have not denied that rule 9 was not
some
violated.
gray areas is there, your lordship. That is why I would like to bring the record, your lordship.
They have not denied the inquiry report was not furnished to me. They have not denied the other procedural lapses were not,
You have
Complex.
to tell us whether inquiry report was furnished or not. If it was not furnished, then it has to go back. Of the point from where it was furnished, and then the other proceedings will take.
Yes, sir.
I don't know, that stage is also as per the High Court, our judgment, Malu, that stage is gone now.
Why?
Yes, one, High Court judgment, it is too late to send back the matter.
Out of that. Which judgment?
Not only they didn't furnish matter, but the.
Which judgment you are referring? Huh?
Gunakanta Tamu.
2015 JLT judgment. I would expect of it.
Not to the. Even the, it has dealt with the other provisions of law.
It is not here. It is not there.
I have an interpretation.
Mr. Book diya na?
Hey, if you want a hearing, then please arrange your paper.
No, no, Mr. Book, sir.
No, we are not addressing you. We are addressing your advocate on record. If your matter is there, if you want the matter to be heard, we have facilities of an email. Send it from the comforts of your
Right.
chamber.
Right.
Whatever matters you want to rely on, so that we can have it.
Sorry.
This is the procedure which was there all along.
In this case, only not only the non-furnishing of the inquiry report, the other provisions of law under Rule 9 have also been dealt with. Rule 7, 9.2, 9.7. Those are also not complied in this case.
Paragraph number.
I'm honored that regarding that 20th. Paragraph 28, madam.
So this is only, see, now lot of water has flown. you are raising this issue of prejudice.
Not only prejudice, the total violation of
That's
the.
right. That violation has caused you prejudice. That's your ground. That's your ground,
Yes.
which you have not explained why you did not raise it on the first instance. You participated, you appeared before the court, filed the court, and petition challenging it. You did not
I
explain.
appeared before them also. I was asked to appear, I appeared, but they didn't allow me to inspect the document, not they allowed the.
Mr. Counsel, you'll have to get your instructions, record whatever you want. We can't give you,
Yes, sir.
you do it on 6th,
Lordship, 1 week time. Your
1
Lordship,
week, then do it on 8th.
8 May.
Yes, 8th
Yes,
May.
yes, sir.
Matter requires the court of the view that in the face of the arguments made by the counsel, senior counsel appearing for the petitioner, questioning the very proceedings, departmental proceedings initiated against the petitioner being violative of Rule 9 of the Assam Disciplinary Rule 1964, on the ground that the relevant documents, list of witnesses, etc., were never furnished. And that apart, the inquiry report was never furnished to the writ petitioner before the order of dismissal, removal was passed by the disciplinary authority. And also, in the absence of any specific averments made in the affidavit filed by
The respondent.
respondent 4, that effect, the relevant records in respect of the disciplinary proceedings initiated against the petitioner and the order of removal passed on the basis of such proceeding will be necessary for perusal of the court. Place this matter again on 8th, by which date, 8th of May, by which date the respondents will produce the reports before the court for perusal.
All right.
Oblige, Your Lordship.
Let pass over this matter for time being. My senior is on legs on code number.
You are there, you argue. Get the file, take the second file and argue the matter. Your senior is on legs, it's a good thing. You seize the opportunity and argue the matter.
Your Lordship, my senior SS Roy is out of station.
Very well, you appear on his behalf. You have already appeared.
Can we get a next date?
No. Yes. You take the second file from the court, go through the brief, we'll take it up at 2 p.m. today. Both of you. No adjournment, or we are dismissing it, or allowing it, depending on how we perceive the merits of the case. 2 p.m., we'll take call of this matter again. Second file. First file, we'll take it.
May it please the Lordship.
Very good.
My lord, background of the case is like this, my lord. I was appointed as epidemiologist of under NHM, my lord. And my salary was fixed at rupees 22,000.
Now, my lord, subsequently, there is some litigation. First litigation is this, my lord, that Ayurvedic medical officer under NHM was given higher salary than medical officer homeopathy was given less salary. Now, ultimately, they approached before your lordship, and your lordship decided that no, they are performing the same duty, so they will get the equal salary as medical officer. So, my lord, now what happened, my lord? Subsequently, the authority was pleased to, after that development, my lord, was pleased to enhance my salary to 30,500. So after what happened, my lord, they given effect from that particular date, but not from my initial appointment. That is my grievance, that my area salary may be given, fixing my salary as at rupees 30,500. So, my lord, your lordship would be pleased to see,
Where is your order?
my lord, my salary,
You're challenging some order, impugned order.
my lord, impugned order, my lord, impugned order. At page 64, my lord. My lord, I filed representation. That representation was not disposed of. Thereafter, I came before your lordship. Your lordship directed to dispose of that representation within a time. That was also not done. Then we filed contempt petition. And after that contempt petition, my lord, this order has been passed. Third paragraph, my lord, it is observed that the petitioner was a BHMS graduate. He was engaged as epidemiologist, IDSP under NHM Assam against advertisement swens of 12 with an initial remuneration of 22,000 per month, which was subsequently enhanced to 30,500 with effect from 1/4/2017. Now, my lord, from 12 to 2017, I claim that my area salary may be given at the rate of 30,500. They increased with effect from 1/4/2017. My initial appointment was 2012.
What was the earlier order passed
My lord.
by the High Court?
My lord. Earlier order, my lord, regarding medical officer hemio, my lord. I am not medical officer hemio. My case will not covered by that. But the thing is this, my lord. When I have qualification, etc., that is why, my lord, that increment has been done. That refixation was done. So, my lord, my simple prayer before your lordship, whether I am entitled to salary with effect from 2012 or from 2007. That is my grievance.
Your appointment order, where is your appointment order?
Yes, ma'am. I'm giving it. Just on
It's 21, Annexure 3.
21.
No, it's 21.
No interview call
22.
letter. That is
22.
not the thing.
22.
23. Yes, my lord.
22,
Page 23 to 29. Your lordship just straight go to page 25, my lord. Monthly remuneration.
Yeah.
Rupees 22,000. Contractual, my lord, it is a contractual appointment, my lord. And thereafter, however, there was revision of pay, my lord, from 2017. The question is this, whether I am entitled from the date of appointment.
You are praying for what? Similar pay? Same pay scale?
Not similar pay, my lord.
Then?
My grievance is this, my lord. My initial salary was 22,000. But the government, after some development, my lord, regarding this homeopathy, doctor and medical officer and Ayurvedic Ayurvedic medical officer, so your lordship decided that they will get equal salary. And after that, my lord, the authority, my lord, increased my salary to 30,500.
Hmm.
So, my lord, my only grievance is this. They are giving effect to that revision with effect from 17. I pray before your lordship that it may be given effect from 12. That is my grievance. They want to say that there is some dissimilarity as medical officer duty, etc. So, my lord, they filed the affidavit. That is not the question. Question is this: when my salary is revised, so it may be given effect from 2012. Your lordship would be pleased to see the prayer. At page 15, my lord. Monthly salary of the petitioner shall not be revised with effect from 3/8/2012 to 31/3/2017. So in that case, my lord, I will get some area salary. The area amount, my lord. That is the thing,
Pursuant to the judgment passed in by this court,
my lord. Judgment regarding this medical officer Hemio and medical officer Ayurvedic. So, my lord, your lordship held that no, they will get equal salary. And thereafter, my lord, the government passed this order and given this salary.
you are now given this salary with effect from
With
17?
effect from 1/8, my lord, 1/8/2007, 1/4/2017.
You had earlier approached the rich court for similar prayer.
No, my lord, I have filed some representation that I may be given
Page number 47,
as number 47. Yes, my lord.
45.
45. Yes, my lord.
This is not a representation, it is a writ petition. 46.
In the writ, I came in the writ petition. Writ petition was filed by medical officer Hemio. In that writ petition, my lord, my name also incorporated. But in the statement, my lord, I did not, I failed to state that I am epidemiologist. So, my lord, government considered these petitioners, but I cannot be considered because I am not medical officer Hemio. So, this judgment, my lord, not given benefit to me because I am not medical officer Hemio. So, from that judgment, my lord, we are not getting any benefit. Only thing is this: the government revised my salary due to this certain development, and thereafter I was given salary 30,500.
You are now working.
Your
as
lordship will be
epidemiologist.
pleased to turn to page 64, my lord. The order whereby my salary has been increased to 30,500.
See, you want it from 2012 as have been done in the cases of medical officers.
Yes, my lord.
That is your claim.
No, my lord, my claim is this, that this increase
of salary, 30,500. I am drawing 22,000, my lord. And from 17, I have been given 30,500. I want that amount, which is less, that is 30,000 minus 22. That much of amount may be area as
From
area
which
salary,
date?
my lord.
From which date? Which period?
Which period is, my lord, with effect from 3/8/12. That is my initial
What is
appointment.
your ground?
Yes, my lord.
What is the ground?
My lord.
There is no dispute that you are appointed in the scale of 22,000.
My lord.
You work.
My lord.
Subsequently,
I work, my lord. I signed the contract also.
whatever
My lord.
you have been working.
My lord.
Subsequently, the pay got enhanced.
My lord.
Now you want it with effect from an earlier date.
My lord.
Why?
Because, my lord, I am performing the similar duties.
Exactly. So
Yes.
you are asking for pay parity
My
with the medical officer.
Yes, my lord. I have requisite qualification. I have requisite qualification medical officer. Though, my lord, I was appointed as epidemiologist. And thing is this, my lord, government is also considered me equivalent with medical officer.
Where?
Medical officer hemio. Otherwise, my lord, what is the reason my salary is increased? That is the reason behind.
From where do you say that?
My lord,
From where do you say that?
my lord, I am saying because, my lord, there is no reason given here. Your lordship would be pleased to.
Reason will not be there in the order. It will be there in the file.
My lord, my
It will
lord,
not be there in the order.
my lord. Your lordship will please to see page 64. In pursuance of order of the Honorable High Court, that has been taken into consideration, my lord. In
Then you-
pursuance of the order of the Honorable Guwahati High Court on 23/1/19, passed in WBC number 36119, read with order dated 9/8/2019, contempt case so and so, notice was issued to the petitioner, Dr. Sanwar Kanad Mullah, for personal hearing on auto to dispose of the representation. Oh, no, my lord, this is not. My lord, my salary is increased to. Huh?
51.
Page 51, my lord. Your lordship, page 51. Initial remuneration of following positions under National Health Mission Assam are hereby revised with effect from 1/4/17 as follows. So, my lord, here my submission before your lordship, no reason has been given. Just it is said, it is increased. Your lordship would be pleased to see epidemiologist, medical graduate, hemio, 22,000 to 30,500. Serial number 17, man. 17. My submission before your lordship, as my salary has increased, without no reason has been shown, just increase. When it is increased, my lord, when it is increased, why it is not from 12? Why it is from 17?
Yes.
Yes, my lord. That is the
I
case.
file our affidavit, my lord. The petitioner, although the petitioner is a, my lord, Bachelor of Homeopathic Medical
We'll
and
come
Surgery.
back at 2 p.m.
Yes, my lord.
My lord. My lord, I want to draw your lordship's attention to page 55. So, my lord, it's an advertisement of 2012. So, your lordship will go to serial number 3.
1 minute.
My lord.
Here.
My lord, I refer to page 55.
Hmm.
My lord, it's a advertisement of 2012. Now your lordship will go to serial number 3. Name of position. Medical officer Hemio. Number so and so. Eligibility classification. Now my lord, remuneration 22,000. So my lord, I was also appointed in 2012. My remuneration was also 22,000, as already pointed out to your lordship. Now your lordship would be pleased to Annexure 8, page 49. Page 49.
You are in which post?
Epidemiologist. My lord.
No. Is it a post reflected in page 55?
Page 55. No, my lord. Medical officer. I am coming, my lord. Why I refer to? Now your lordship will please to. So I want to say that medical officer Hemio salary is 22,000, as I referred, my lord. Now your lordship will come to page 49.
Yes.
Here what happened, my lord, by this order, the monthly remuneration of petitioners in WPC 246 of 2013, medical officer homeopathy, engaged under the National Health Mission Assam is revised to 30,500. So, my lord, medical officer hemio revised per month 30,000 with medical officer Ayurvedic. Now your lordship will consider it is with effect from 1/4/2012. There is the case, my lord. My revision 22,000 to 30,500 with effect from 17. And here, my lord, I am regarding salary, my lord, I am similarly situated, 22,000. Their salary increased to 30,500, medical officer hemio, with effect from 1/4/12. So, my lord,
No, where is
what is the reason?
your advertisement?
My lord,
Where is the advertisement for your post?
my lord, advertisement, yes.
Annexure 2.
Annexure to page 19, my lord.
190.
19.
Epidemiologist.
My lord.
Which one? First one or
District level. District level.
district level? What is your salary?
At that time, my lord, salary 22,000.
But it says 40,000 and 25,000.
Yes, my lord. My lord, as per NSM norms, medical graduate, my lord, your C, para C, my lord. Close C, epidemiologist at district level, 25 numbers, medical graduate, postgraduate degree, so and so. B is the medical graduate MBBS. Their salary will be 40 years, so and so, my lord. person from public health background. B.
What is
Now,
your-
now C, my lord. Now C. Medical graduate Ayush. So, my lord,
As per
I want to place before your lordship. Ayush includes Ayurvedic, Hemio, one is,
Ayurvedic, Unani,
yes, my lord, Ayurvedic, Unani, and this,
Siddhi. Siddhi.
Siddhi, and homeopathy.
yes, my lord. So, my lord, Ayush, medical graduate. I am medical graduate Ayush, a homeopathy, my lord. So, my lord, my salary, as I have already given, here it is written C, category C, as per norms and NRHM norms. So, NRHM norms, by following NRHM norms, I have been given 22,000, as I have referred to the agreement, my lord, already, at page 51. So, my lord, my humble submission before your lordship, as I have referred page 55, medical officer homeopathy, their salary is fixed at 22,000. My salary fixed at rupees 22,000. I have already referred to your lordship, page 4950. Here, medical officer hemio, their salary increased to 30,500. Now, only thing is this, my lord, with effect from 1/4/12. My salary also increased to 30,500. So, my lord, that is with effect from 1/4/17. That is the problem. Why effect has been given from 1/4/17, not giving from 1/4/12? Because, my lord, I am treated, I am equivalent to medical officer hemio, 22,000. That is their document, my lord. That medical officer hemio will get rupees 20,000, 22,000 per month. Their salary increased to 30,500. And my salary also increased, 30,500. Effect has been given in the medical officer hemio, my lord, from 1/4/12, page 4950. Further, in my case, it is given effect from 1/4/17. So I am claiming this part, my lord.
Yes, my lord. Although the petitioner is a BHMS degree holder, my lord, but he was selected and appointed as epidemiologist in pursuance of the advertisement as annexed in Annex 2, my lord. And thereafter, some of the medical officer homeo, my lord, approached this honorable court for enhancement of remuneration at par with the Ayurvedic medical officer, my lord. And honorable court allowed that petition, my lord. And thereafter, the petitioner, along with 142 homeo doctors, my lord, along with them, he approached this honorable court seeking similar order, my lord. And but the petitioner did not mention in the writ petition that he is working as the epidemiologist, my lord, in that writ petition.
In that writ petition, the other homeos were what, medical officers?
Yes, my lord. But he did not mention his post, my lord. And that was also allowed, my lord. And thereafter, therefore, as he is working as epidemiologist, my lord, so his remuneration was not enhanced as medical officers, my lord. And but as per order dated, my lord, in 51, my lord.
So for enhancement, what is the process? It on a basis of a proposal sent by NHM. How is it?
Yes, my lord. Proposal was sent for the Ayurvedic, my lord. Then,
What we want to know is
yes,
what happened to the medical officers of homeopathy? When were their salaries enhanced?
yes, my lord. That
When,
was
from which
proposal
date?
Central.
From which date? You said
Oh.
petitioner has approached his court earlier,
Yes, my lord, from 2012. my lord.
2012.
Yes, my lord.
So now the question is, why is the petitioner left out?
He's not holding the same post, my lord.
So, but then you have ultimately enhanced his salary.
But
Is it the case of NHM that since 2012 there was a decision that you will enhance the salaries of medical officers? Subsequently, for epidemiologists also, you have taken decision for.
along with some other, your lordship may please sit up page 51 of the writ petition, my lord. The initial remuneration of the following positions under NRHM, my lord, Assam are hereby revised with effect from 1/04/2017. That is post is totally different, my lord. Although he is holding the degree of PMH. Claim the same remuneration as the medical officer homeo, my lord, as he is holding the different post, my lord. And job responsibilities also different, my lord. In my affidavit, I have written, my lord, stated that. In my affidavit, my lord, page 67.
But Mr. Sheikh, if you come to page number 52, we'll come to page 51.
51 one.
Yes, 51 is the order by which your pay was revised.
Madam.
Serial number 17, epidemiologist.
Yes, madam.
From
Medical
20,000
graduate hemio. Huh?
From 20,000 to 30,500.
Well, it is wrongly written, madam. It is 22,000.
All right, whatever.
Yes, yes, yes.
Then come to the next page, page 52.
52.
Kindly see serial number 38.
Medical officer hemio.
Medical officer homeo.
Medical officer homeopathy.
Homeopathy.
It is also 22,000, my lord.
Correct.
30,500.
But this post, medical officer homeo, is also enhanced with effect from 1/4/2017. This 1/4/2017.
My lord. But your lordship, that is one order. That is one order. That is this medical officer homeopathy, whether they come or did not come, 19. Your lordship would be pleased to turn to page 49. Page 49.
Yes.
In pursuance of Honorable Guwahati High Court's order, so and so,
No,
and subsequent contemplation, so and so.
We have seen that order.
Madam, medical officer homeopathy engaged under National Health Mission Assam is revised to 30,500 per month at par with medical officer Ayurvedic under NHM Assam with effect from 1/4/12.
That is all right, but this is in pursuance to the order of the court.
In pursuance of the order of the court, that is the case, my lord. In pursuance of the order of the court 1/4/2012. That's all right. Now, your lordship, salary of medical officer hemio, as I referred to your lordship, is 22,000. It is increased to 30,500. My salary also increased to 30,500. So I am treated equivalent to medical officer. Otherwise, why I will be given?
Quite right, but
My lord, why I will be given this
come to
30,500?
Come to
Now,
page number 52. There is also medical officer homeopathy.
my lord, that medical officer homeopathy, my lord, that medical officer homeopathy did not raise the grievance before your lordship. They could have. They did not, but I raised the
You did, but you are not treated as a medical officer because by
My lord,
virtue of
my-
this
my
order,
thing is this, my lord.
by virtue of the order, there was a writ petition filed. You were a party to the writ petition. You got an order in your favor.
No, my lord, because in the repetition, I was there, but unfortunately, I did not mention that I am working as.
So you did not mention it, so that benefit of order is not given.
No, no, benefit of order will not be given to me.
That's right.
I am not covered by that because I am not the medical officer hemio.
Correct.
Only in a very narrow campus. That medical officer hemio salary 22,000. Their salary increased to
No, whatever you
30,500
see, whatever you
by,
are
by the order of the Honorable High Court.
that's by the
Now,
order of
now
the
my
court.
question is this, my lord. I have been created as medical officer hemio, but effect has been given from 70. That is why, my lord,
is
that
what we
order
are
I have
saying,
sent.
that effect has been not been given to epidemiologists only.
My lord.
There are 46 posts.
Well, maybe others may not affected, may not come, but I affected, I have come, my lord. Because, my lord, I am medical officer hemio, my salary has been increased to 30,500. Why? Reason is this, my lord, I am holding a post of 22,000. I am holding a post of 22,000. That is why. What is the reason behind, my lord? Otherwise, I am holding the post
go
of
and ask for the
22,000,
reasons.
so it is increased to.
Why are you coming to the court?
My lord.
You should ask the reasons from the department. They will tell
Well,
you.
department I approached and department rejected my claim.
Where is your?
Yes, my lord. That rejection order is the impugn order.
64.
Page 64. 64. Yes. I come before your lordship as my representation was not disposed of. Thereafter, my lord, your lordship directed to dispose of the representation. Then I filed the contempt petition. Then they disposed of this by this order. They want to say then that I am not entitled. It is observed that though petitioner was DHMS graduate, he was engaged as epidemiologist, NSM, against advertisement number so and so with initial 22,000 per month, which is subsequently enhanced. Now the question, my lord, subsequently enhanced.
They have said that it is not similar and
Not-
equivalent.
No, my lord, they want to say that epidemiologist and medical officer hemio is not same. But I place before your lordship, medical officer hemio, as per salary, is same.
So salary may be same.
My
That
lord.
does not necessarily mean that the job profile is also the same.
My lord, that is there, my lord. If that is so, my lord, if that is so, what your lordship pointed out, if that is correct, that it is not similar. In that case, my lord, they brought me to similarity of medical officer hemio
Maybe.
by giving 30,500.
Maybe
No,
that-
otherwise there would have been some difference. I said,
No,
they
no.
have given.
No, no, Mr. Sheikh, it is not like that.
My lord.
You may be drawing the same level of salary, but your job profile could be different.
Job,
And on the
no,
contrary,
I'm not saying that I may be treated as medical officer.
that's right.
I'm not saying that I'm medical officer. I'm a epidemiologist. No problem. But thing is this, my lord, my salary also increased. They have been given effect from 12. I have been given effect from 17.
They means medical officer,
Yes, medical officer.
right?
Medical officer.
You
medical
say you are
officer.
not equivalent.
I'm not equal, but I am working from
You
2012.
may have been
They
working.
are also working from 2012.
No, mere submission will not do. You have to
No,
support
no,
your argument.
your lordship will consider that
See,
22,000.
either you say that medical officer and epidemiologist perform the same nature of job. Therefore, when the medical officer's salary was increased, your salary ought to have been increased with effect of the same day. That is not your argument. Your argument is that medical officer, epidemiologists are different.
Medical officer, epidemiologist not. Medical officer, only epidemiologist post. It is not medical officer.
I know.
Yes, ma'am.
You are saying medical officer and epidemiologist are two different posts.
Yes.
nature of job is different.
Yes, job different.
Subsequently, your salary was also enhanced, making it equivalent to medical officer.
Mhm.
You want it with effect from the date when their salary was enhanced.
My lord.
On what basis?
Now, basis is this, my lord. Now, another question will rise. Why their salary from 12? Because they were working from 12.
You are wasting time. Don't do
My
that.
lord. My lord.
You give us a legal basis for
Basis
support
is
to
this.
your
my lord.
claim.
Basis is this. Basis is this.
The authorities
Initially, I
have
am.
taken a decision to
My lord.
enhance salaries of some posts,
My lord.
including epidemiology,
My lord.
and that order is with effect from 2017.
My lord.
Medical officers had approached this court
My lord. My
on
lord.
the ground that their salary should be made equivalent to medical officers of MBBS, Ayurvedic and all.
Yes, my lord.
And that was answered.
My
You
lord.
were subsequently you were a part of the homeopathy officer, medical officers.
My lord.
That order is also in your favor.
My lord, I will again trouble your lordship to page 51.
51.
My lord.
Yes.
Your lordship will see the order. Initial remuneration of the following positions under National Health Mission Assam are hereby revised with from 1/4/2017 as follows. Now the question is a simple order, madam. Only thing is this, why effect has been given from 1/4/17? What is the reason behind?
That reason you have to ask for the department by filing necessary
My lord,
application.
I have filed this representation.
You have filed where is your representation?
Yes, my lord, representation is there.
Where is your
Representation, my lord. Representation,
17,
yes.
17, 53.
My lord, 57.
57 is a type copy of something where
63.
63.
this is submission of the court's order.
No, my lord. My representation, your lordship,
Page 57.
page 57.
That is no ground.
Mission Director, most
We have seen
respectfully,
that.
with reference to the subject, I have the honor
Are
to
you,
state.
are you placing any reliance on any authorities?
My lord,
Any authorities?
regarding this, my lord. My lord, as on today, no.
All right, heard. We'll pass order.
My lord.
Say,
Hey, boss.
all right. We'll pass orders.
My lord.
This post.
Oblige, your lordship.
Yes.
Your Honor, Your Lordship, I'm too new in this profession. Today is my second day. Please consider me a date.
Hmm?
At least 1 week.
You have further responded. You take your seat.
Yeah.
Let the petitioner argue. You take your seat.
My lord, it may be considered only 2 days in profession.
That's why you asked her to take her a seat. Yes.
I am on behalf of the petitioner that I joined the CRPF in the year of 2004, and on 7th and 2005, I was terminated on the ground of cheating in the paper for the examination of 10th standard. But in the trial court, I was not proved guilty and granted me the benefit of probation.
Which order are you putting to challenge?
Import order, page 48.
That's from 45.
Page 48, clause B.
No, but the order begins where?
Okay, wait. Page 45.
Where is Mr. Muzumdar?
He is on code number 14.
All right, you call him, we'll pass over for the time being. Yes. Time being.
Claim of the petitioners regarding the payment of FPP or computer increment money. That is, that the bank has now accepted. In fact, perhaps that is the reason they may not be appearing. But I have this communication from the government of India.
What is his prayer?
This prayer is basically for FPP or
FPP.
yes, FPP.
That has been considered.
That has been, in fact, this dispute is a pan-India dispute. It has reached up to the Supreme Court. Contempt petitions were also filed. Those were also, because it is not of this bank alone, but of a multitude of RRBs all over India. And now, all those.
Computer increment.
Lordship, yes, essentially, is because this is basically the nature of it is called computer increment for the reason that with the gradual computerization, those persons who are doing those jobs.
So you are saying FPP is equivalent to computer increment?
But as far as we are concerned, it is equivalent to the computer. Both are the one and the same.
Who's for the petitioner?
One Mr. Bhattacharjee was appearing earlier. In fact, we have now started paying them as to whether these petitioners have been paid or not. That I cannot say, because unless the SPF number is there, I cannot confirm. Otherwise, we are paying to all the eligible. We are bound to pay.
Right. Heard. And none appears for the petitioner, Mr. K. Ganguly, the respondent bank. The grievance for the petitioner before this court is seeking a direction for the bank authorities and to set aside the impugned order dated 3/2/2021 passed by the Assam Grameen Vikas Bank, whereby the prayer for release of fixed personal pay within bracket FPP to the petitioner was denied. So, pleadings have been exchanged at the petition. Whereunto they were the matter is caught up. Mr. Ganguly submits that pursuant to the Government of India pursuant to a decision taken, which department?
With this Ministry of Finance.
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 Finance Department, Government of India, Finance Department, Government of India, decision taken. And as per the memorandum of settlement arrived at between the Indian Bank Association and Employees Association, the regional, what is RRB?
Regional Rural Bank.
Regional Rural Bank, like the respondent, are advised to refix the pay of the pension of eligible officers and employees and pay them the due amount of arrears after getting approval from the directors. Stop. Mr. Ganguly, in effect, has submitted that the decision has been taken appropriately by the Ministry of Finance to release the dues and the arrears as prayed for by the petition. So he therefore submits that demand of the petitioner have been repressed, the registration may be closed. Mr. Ganguly, however, fairly submits that he does not have the instruction as to whether the petitioners have been granted their plea. In the absence of the petitioner, counsel for the petitioner, we deem it appropriate to have the matter listed on. When can you get it?
But I can only get it when they give me the SPF numbers, because in fact there may be 3-4 persons with same name. Very difficult for us to identify. Huge exercise.
Your bank there, you can find out which employees they belong to which bank. Their details are there.
I'll try to take that, make that. 2 weeks, then after 2 weeks.
Matter be listed after 2 weeks. We'll keep it after 1 week. If it is sorted out, you sort it out.
But
why
without
temporary matter?
Without the SPF number.
Right, after 2 weeks. List according.
Obliged.
Yes.
My lord, before going to the meat of the case, my lord, during pendency of another petition in another high court on the same issue, he has filed this writ petition. On this issue, he filed a writ petition before the Honorable High Court of Patna in 2002 April. And this writ petition was disposed upon 13/7/2022. But this petition filed declaring that no writ petition has been filed in this issue before the or pending before the court, before any other court. Now, this is the order and a writ petition. He ought not file this writ petition, but I'm not saying anything because he has lost one of his eyes for the nation. But it is not acceptable.
He has been subsequently promoted.
Promoted, but
He is asking for
seniority was not given from 2011 my.
Yes.
And
What do you say?
let my senior come.
You give it to her.
Yes, let us say, I'm okay. More spoken to him like.
Yes, Mr. Pegu, anything?
Regarding my lord, back wages. Back wages.
Back to it.
My lord. He was dismissed from service and later on reinstated by a order of this honorable court, my lord.
We are expecting a similar submission, so therefore we have not even opened the file. We are passing it over
My lord.
for the time being. Please inform Mr.
Lord.
Mozumdar.
Or some other day, my lord, then.
Let it remain later.
Item 13 will let it be taken up after some time, my lord. My senior Mr. BD Das is on election code 4, my lord. Just express some urgency.
Why do you have these matters fixed? You have to find a way to appear in court. If he is not there, you should argue the matter.
I'm not even on record, my lord. He has just told me to rush to court and address your lordship on that.
My lord will take up some other day, my lord. It will take some time.
Let him.
Yes, Mr. Sharma,
Some urgency is there. Mr. Das is late in this case.
you are there.
Good. That should be taken up after some time.
We must have some matters to take up after some time. Every matter is after some time, then what will we do?
My
Yes,
lord,
all right, until the list is exhausted.
Yes.
Yes.
May I please, your lordship? Here, lordship, Mr. S.S. Roy is today out of station, lordship. And in fact, he received the record. The matter will take on 15th of May, lordship.
We're not fixing any date. It will be listed whenever the registry finds the slot. Get it listed.
Record already received. Only, in fact, lordship, we have taken consent also. But morning, we supposed to, lordship, have to pray for adjournment, but
All right. Let it come whenever it.
lordship,
Lordship, a date may be fixed, Lordship. It is dismissal from service, Lordship.
either on 15 or after 15.
On-
You're not fixing
Lordship.
dates. Please understand the
Lord.
difficulty. We fix dates, you are not ready to do the matters. If you tell us that you will be ready to do the matters, we'll fix the date.
Lord.
You tell me, you are not appearing,
I am not.
you give us the assurance on behalf of Mr. Roy, we'll fix it.
But record is received. That
Then it'll come next week. We'll see what happens.
Lordship, some
Next week.
urgency, Lordship.
Where? Next month.
Public.
Yes. It's a pleasure post, isn't it?
Yes, my lord. It's a pleasure post.
Then
It's a pleasure post. And in fact, my lord, after 2018 amendment, my lord, the authorities can remove me at any point, my lord. And this issue has been already been decided by a single bench of this honorable court, my lord. However, my lord, in that case, my lord, the honorable Guwahati High Court has ruled that such exercise can be carried out if the power is not exercised arbitrarily, man.
Where is your appointment order? Page 14.
Yes, my lord.
You are serial number 1.
Serial number 1, my lord.
Okay, then
Then, my lord, all the formalities were taken care of, my lord. Oath was taken, my lord. Everything was taken. Then, my lord, what happened? Despite that, I was not handed over the charge, my lord, of vice chairman, my lord. Then I have filed a complaint.
so
before
you are serial number 1 or 2?
I am serial number 1, my lord. Hemakanto Deka.
Serial 1. All right.
The other two are member, my lord. I have been appointed as vice chairman.
Yes.
Then, since the charge was not handed over to me by the chairman, my lord, on 4/4/2024, I have filed a complaint before the commissioner secretary, my lord. While this complaint was pending, my lord, since the authorities are not taking any decision, my lord, I have prepared a writ petition, that is WBC number, my lord. I have annexed the order, my lord. Annexer 6 at page 8. WBC 3375/2024, my lord. The Honorable Court was pleased to issue notice in this case, my lord. Hereafter, suddenly on, my lord, on 5/7/2024, my lord, my service was terminated. My appointment was cancelled, my lord. That is at Annexer 7, page 21, my lord. That imprint order is that.
Who is the chairman?
My lord, chairman at present.
So at that point in time, is it a minister?
No.
Who is the chairman? Elected person.
Not elected person. He is also nominated person.
Nominated.
He is also nominated.
Who is to give you the charge? Who has to give you the charge?
My lord, the chairman, my lord. The chairman is to give me the charge, my lord. Suddenly, my appointment was cancelled, my lord. Then this present writ petition was filed, my lord.
So what is your ground for challenge?
My lord, may kindly, there are certain guidelines, my lord. That is, I have annexed at page 23, my lord. Annexed 8, my lord. My lord, his guidelines hold the field in respect of matter concerning, my lord, appointment and removal of the members of the Development Council. Now, my lord, may kindly come to page 29, my lord. Clause 7 is the criteria for removal of members, my lord. Condition for removal of members, my lord. Roman 1. And Roman 2 are the term condition under which I can be removed from the post, my lord. My lord, may kindly come to page 31, my lord. These are the conditions, my lord, for violation of this condition, I can be removed from the post of chairman or vice chairman or member, anything. Hereafter, my lord, after filing of this writ petition, my lord, the respondent authority has filed their rejoinder affidavit, my lord. According to them, my lord, an inquiry was conducted by the director, my lord. the counter affidavit filed by one Anamika Medi, respondent number 3, my lord. From this affidavit, counter affidavit, I came to know for the first time that the chairman and some other members have filed a complaint against me, my lord, with some allegations, my lord. On the basis of that complaint, my lord, an inquiry was initiated against me, and after that inquiry, my lord, I was my appointment was cancelled. Now, my lord, may kindly come to paragraph 7, my lord, page 44. Paragraph 7, my lord.
Where does one get the uh, under what provision is this? What is this council? Council is a statutory council.
It is a statutory council.
Where is under what act?
My lord, not under any act, my lord. It was constituted under a notification of the government.
Where is the notification?
Notification, my lord, notification I have annexed, my lord. Annex 8 of the writ petition, my lord.
It has one chairman, one vice chairman.
Earlier, it was one chairman, one vice chairman, my lord. Subsequently, one chairman and two vice chairman post was made, my lord.
Where?
My lord, I have annexed that notification, my lord, in my reply affidavit, my lord. Reply affidavit filed by the petitioner, my lord. At page 70, my lord, Annex A. The numbers of the members were increased from 15 to, my lord, 25. Then, my lord, another post of vice chairman was created. This is the notification. So I have been appointed in the second post, my lord. Now, my lord, in their counter affidavit, my lord, the respondent number 3 has stated that pursuant to the complaint, my lord, the director of welfare of SC and BC Assam was instructed to examine into the matter, my lord, and submit a report.
But these are pleasure posts.
These are pleasure posts, my lord. These are pleasure posts, my lord. The issue has been settled, my lord. This issue has been settled by the single bench of this honorable court in the Barak Valley Tribal Development Council and another, my lord, where a single bench of this honorable court has held that a person can be removed at any time, but that exercise the power of the manner in which it was exercised, it should not be arbitrary, and it should be in
If it is pleasure post, then what arbitrary?
arbitrariness.
Pleasure post.
Yes, my lord, arbitrariness, and also the single bench has stated, my lord, honorable single bench of this honorable court has stated, my lord, it should be done in light of paragraph 22, 33, 34 of the Constitution bench judgment passed in BL Singhal's case by the Honorable Supreme Court, my lord.
What is that provision?
My lord, may I hand over a copy of the Honorable Supreme Court, sir? Yes, my lord. And in fact, my lord, at paragraph,
Single bench judgment letter.
yes, my lord. Relevant portion is at paragraph 25, my lord, of the single bench judgment, my lord.
Here the writ petition was dismissed.
Dismissed, my lord.
Then
But this observation was given by the at paragraph 25, my lord.
that observation is the observation of Singhal.
My lord.
BP Singhal.
BP Singhal's case,
Right.
the authority laid down by.
Now, how does one find out it is not arbitrary and capricious?
It is arbitrary, my lord. Kindly see, because the respondent authorities has said that they have come to, they have passed this interim order pursuant to an inquiry, my lord. But from my additional affidavit, my lord, it is clearly revealed that after passing of the appointment cancellation order, my lord, the inquiry report was submitted as on date 5/7/2025, my lord, 5/7/2024, my lord. There was no inquiry conducted, my lord. My
Where is
additional,
that inquiry report?
my lord, page 75, my lord. Sorry, my lord, page 76, Annex C, Annex C, my lord. The deputy commissioner was directed to inquire into the matter, my lord. The deputy commissioner of Morigao district has submitted this report on 29/1/2025, my lord. The main allegation against me that I do not belong to the Koch Rajbangshi community, my lord.
And the inquiry said you belong.
I belong to that. And this inquiry report was filed way after the dismissal order, my lord.
Yes. Respondent.
Lordship, I am appearing for Social Justice and Employment Department, Your Lordship. We have filed our affidavit, Your Lordship. In this matter, law is already settled by this honorable court, Your Lordship. It's a doctrine of pleasure, Your Lordship. And as per the affidavit, Your Lordship, complaint has been received and inquiry has also been
The
conducted, Your
inquiry is
Lordship.
in his favor. Inquiry is in his favor.
But Lordship, after complaint has been received,
Complaint is that he did not belong to the Koch Raj company. inquiry was made and
No, Your Lordship, there are some other allegations too, Your Lordship.
if a complaint is made, there is an inquiry.
Yes, Your Lordship.
Where is the inquiry report?
And Your Lordship, as per my information, Your Lordship, already two vice chairmen are working, Your Lordship.
Where is that?
Lordship, that is my,
Your affidavit is not there.
not there, Your Lordship, but that is my information, Your Lordship.
Your information is irrelevant unless you take it on record.
Yes, Your Lordship. Lordship,
Whether these two vice chairmen are working,
working, one is from 2021 and one is from 2022, Your Lordship. It might,
when was he appointed?
My lord, on my lord, 5/3/2024, my lord.
Now, if chairmen are, vice chairmen are already there, where is the necessity to go into that inquiry? Find out whether he belongs to both or not, Rajput or not. If you don't intend to appoint him, the vice chair, why go into that inquiry?
Lordship, that's true, Your Lordship. But Your Lordship, our main contention is the doctrine of pleasure, Your Lordship.
Correct, but doctrine of pleasure doesn't mean that you can throw out anybody anytime, midnight. And it doesn't expect the court to exercise judicial review, find out whether the basis for exercising your doctrine of pleasure, that much should be there before the
Yes. Lordship, they allow me some time. Okay.
after filing affidavit, why leave the matter for instruction?
Then Your Lordship, may if Lordship permits, I can produce the record, Your Lordship.
We don't want to see your record. You tell us from your record that what is the basis.
Yes.
Heard Mr. M.K. Sharma are happy.
Are
Decca for
social justice and
social
empowerment.
justice or respondent for the petitioner is equipped by order to be given for I can Postras Pongsi. What is the council name?
My lord, Post Rajbamshi Development Council.
Postras Pongsi Development. By dated. Twenty-one 5/2014. Issued by the Government of Assam Department of Welfare of Plain Tribes and Backwards. So, it is the grievance of the petitioner that pursuant to his appointment as the Vice Chairman of the Council, he was arbitrarily removed, purportedly on the basis of a complaint lodged by the Chairman.
Chairman and some other member.
Chairman himself. Whereas the respondents have filed their affidavit and have disputed the contentions of the petitioner. It's submitted. It is submitted by the council, respondent council, appearing for the Department of Social Welfare,
Social justice and empowerment.
Social Justice and Empowerment. That the at the time of the appointment of the petitioner, they were already vice chairman who are employed and who had assumed offices under the post of the development. It is also submitted that there were complaints made against the petition, and taking into account these aspects, the petitioner was removed by the government. after hearing the council some length and after perusal of the minutes of record, it seems that an inquiry was conducted pursuant to the alleged complaint. The findings of the inquiry reveal that
Page 77.
the additional affidavit filed by the petitioner. The inquiry report was submitted by the additional of 9/1/2025, whereby the primary allegation made against the that he did not belong to the post Rajbang community has been found to be the inquiry. However, as the council of the Department of that besides this allegation, as per her, that they were not the vice chairman appointed prior to the appointment of according to the point otherwise so this submission however submission of the learned council however is not supported by the pleading. So what do you want to produce now?
Lordship, the relevant records.
Under such circumstances, the request of produce the relevant report shows that at the time when the persons in post, they were already persons employed. So, vice chair, the post this report produce
Lordship, after 2 weeks.
on 16th?
Yes.
16th.
Okay.
List accordingly.
W.
There are two writ petitions.
The other one is the earlier writ petition, my lord, whereby I was not allowed to join. I challenged them.
Not allowed to join.
Allowed to join
Yes, my lord.
after your order.
Yes,
That has become infructuous now.
that has become infructuous.
Then we close this petition. WPC 3375 Belagali Koidu, filed by the petitioner in WPC 3566 was filed by the petitioner in WPC to challenge the action of the respondent in not permitting the petitioner to join in his post of vice chairman, Post Rajbangshi Development Council, pursuant to his appointment. Subsequently, of course, the petitioner was removed by the impugned order dated
5/7/2024, my lord.
5/7/2024, which came to be essayed in WPC 3566. Accordingly, this writ petition has become infructuous. They therefore stand dismissed. Interim orders, if any, stand vacated.
Right.
My pleasure, Lordship. Lordship may pass over the matter.
My lord, may fix another date, my lord, because I don't know, 11 also, my lord, same advocate, my lord, Armuzan is in another court, my lord.
Please, let's at court number 14.
List again next week.
Next week, my lord, my lord, 15, my lord, 15th of.
List again in the part 2 hearing list.
Yes,
Next part 2 hearing list available.
yes. Like.
Same order. Part 2. Part 2 hearing list. Council not available. That will be listed in the part 2 hearing. Yes.
11 and 12 also.
11 and 12. Same. We are referring these matters in the absence of the counsel for the petition. You are appearing in which item?
Item number 12.
12. Is there something you wanted to submit before the
No.
Obliged, sir.
Let it come up on 6th, my lord, next week, my lord.
We will keep it for hearing list.
But,
It's better to have it in the hearing list so that
Yeah, that
we
will be
can
there,
take it
madam.
up any day. Instead of fixing a date, the matter, the person is not available.
that is my humble request, my lord, because I am not even on record, my lord. My senior has instructed me there, therefore I am making this prayer.
6th, we can't have it.
On 8th, my lord.
All right, 8th. Let it be on 8th.
Obliged.
Yeah.